Upgradation? No, not possible. Upgradation not possible. 2009 appeal.
Actually, the
I have some old appeals.
yes, Lordship, but the fact is that encroaching my land, the land was given by the was given to third parties by the respondents by Lordship. There are some illegal activities happen on my land.
So much applications are there. What are the applications?
Lordship, on the last occasion, one application was moved for substitution of the name of the respondent number 1.
That was done.
That was done before before.
Very well. Come on next week, not this week. Okay, next Wednesday.
Grateful, Lordship.
Call the list.
Respond.
Yes.
My lord, I do not know, my lord. Mr. Gopal.
Lord, I am for the respondent. So, not I am the plaintiff decree holder. Thereafter, preferred an appeal. I obtained a decree of eviction. They preferred an appeal that was dismissed. Thereafter, second appeal preferred in 2010, and today we are in 2025. In the meantime, the defendant died, so the appeal has abated.
Appeal has abated.
Yes.
Who is for the appeal?
I do not know, my lord, what Mr. Gopal Chandra Ghosh is the appellant on behalf of the appellant. My lord.
An application
I
has
do
been,
not know, my lord, what is there. He told me, but
an application has been preferred. We have been
coming, my lord. Can't take up short pass over, my lord.
We have been served with an application. Can 2. We have
Application you have filed.
no. They have filed application for substitution, but that is
And number?
2.
That is there, my lord.
Can 2. We have been served. I do not know whether that is in your lordship's copy or
Yes,
not.
sitting as a in time.
Substitution.
In time.
In time. আপনারা তো in time ই বলছেন।
Tell your lordship kindly allow this substitution application, my lord.
No, I have objection. After beyond 90 days, this has been filed.
এই তো বলছি যে
এটা
Where is
আপনারা
can?
করেছেন।
Give me the can. Can is running the list. Can 2 of 2020. 24. Can 2. Can 2 টা কোথায় গেল? ট্যাগ করেনি কেন?
নতুন অ্যাপ্লিকেশন। এটা কপি দিন না। Defendant died on 8th April 2024, and this can has been preferred in September.
Time bird.
November. No. As per Article 120, 90 days is this limitation. And we have communicated it immediately after the death of
that
the
is, my lord, stated in paragraph 5 and 6, my lord. Your lordship kindly see.
copy দিয়ে দিন না my lord.
এই কপিটা দিন তো।
May I have liberty to mark? This is my copy, there are markings.
দিন। He is residing at USA. That is the main
কেন আসবে না হয় নাকি? লিস্টে আছে। কি করেন? ট্যাগ করেন না কেন? গুলো ওদের কাছে কপি নিয়ে করতে হবে।
Mr. Ghosh has come, my কি বলো? No, second appeal, lord. The sole
Application for substitution.
sole respondent, lord.
Respondent number 1. Sole respondent.
No, there are 2 defendants. দুজন defendant তো। দুজন defendant, একজন proforma আছে। There is a proforma is there.
Proforma was one of the heirs of the tenants. Put for eviction.
We obtained a decree as first appeal dismissed, second appeal in 2010, and we are in 2025. Still the second appeal is running. There is no stay. We cannot execute the decree also, in spite of there is no stay. Stay, আমাকে বলো stay নেই?
Stay is there.
Stay আছে? I am sorry, my lord, I am sorry. কি বলছেন? Stay নেই বলছেন।
শ্রীমতী তপতি সেন.
Yes.
Proforma respondent is there. Alok Kumar Das.
মেন ফাইলটা পাচ্ছি না যশ, আমি তো ওর ফাইলটা দিয়েছি।
Yes, what is your submission?
My lord, if my lord kindly comes to paragraph, if kindly first come to my lord, order 22 rule 4.
Yes.
May I read, my lord? Order 22 rule 4, procedure in case of death of one of several defendants, CPC, or of sole defendant, where one of two or more defendant dies and the right to sue does not survive against the surviving defendant or defendants alone, or the defendant or sole surviving defendant dies and the right to sue survives, the court on an application made in that behalf shall cause the legal representatives of the deceased defendant to be made a party and shall proceed with the suit. Now, my lord, I am relying on sub-rule 3, where within the time limited by the law, no application is made under sub-rule 1. The suit shall abate as against the deceased defendant. Sub-rule 1 is the power to make an application, and sub-rule 3 is the procedure where is the situation where the suit abates. Here, my lord, what has happened? Thereafter, I am relying on order 22 rule 9. Effect of abatement or dismissal. Where a suit abates or is dismissed under this order, no fresh suit shall be brought on the same cause of action. Sub-rule 2, I am relying. Sub-rule 2 and sub-rule 3 of order 22 rule 9.
So you want one prayer for abatement was required.
Lord, I have prayed for.
Exactly.
Lord, kindly come to page.
They are praying for substitution, but substitution is the period is 90 days. Thereafter, it cannot be substituted. Abatement is something else. That is my case. Kindly come to order 22 rule 9. The plaintiff or the person claiming to be the legal representative of a deceased plaintiff or the assignee or the receiver in the case of an insolvent plaintiff may apply for an order to set aside the abatement or dismissal, and if it is proved that he was prevented by any sufficient cause from continuing the suit, the court shall set aside the abatement or dismissal upon such terms as to cost or otherwise as it thinks fit. Now,
How many cost you want?
now, my lord, the sub-rule 3, the provisions of section 5 of the Limitation Act shall apply to applications under rule 2. There is no condonation of delay application.
Not needed.
There is no condonation. 90
But
days
it
is
within
the
150
period
days.
for substitution.
It is within 150 days, not only simply
Kindly,
abatement should be set aside and substitution should be allowed.
kindly see Article 120. It's 90 days.
Oh, no, that is not there.
Yes, I know. That is the provision. All know.
Yes.
All civil practitioners know. That is the no issue.
Here the
This is
application,
that one prayer for abatement is separate application is required according to the law.
a
No,
condonation
I
of
told you
delay
that-
has to be there because 90 days has expired.
So this honorable
That
court
is
within
nowhere.
section 5, the limitation should be prayed in the same application. That's why, my lord, it is prayed that after setting aside abatement, substitution may be allowed. It is within 150 days.
Yes.
150 days is not the substitution. It is 90 days is the substitution.
Yes. 90 days is the substitution.
And 60 days.
Thereafter 60 days is within 60 days one application for abatement can be filed. This is the law.
But he has prayed for substitution. That cannot be done beyond 90 days.
He has filed a single application
For
for
substitution,
substitution.
that
as well as
period
the
has
abatement.
gone.
This is the
That period has come and gone. So as it has to be supported by section 5.
okay.
Even order 9 rule 3 also, order 22 rule 9 sub rule 3 also says that section 5 of the Limitation Act will apply.
There you are.
My lord, kindly allow the substitution and not fix a date for hearing. We are also eager to get the matter heard.
Who are the persons? Substituted persons. You are appearing on behalf of all the substituted persons.
Yes, yes.
Have you filed the vocalatam or no?
Yes, yes. Vocal
Vocal
file.
Then, my lord, there is nothing.
So when the matter can be heard?
Lord, your lordship, as a lordship.
I am having a decree, my lord. Kindly expedite the hearing of the
My lord, what happened, my lord?
If you both are ready, I can start the hearing. Fix a date.
fix a date, my lord. Kindly. But my contention may be recorded, my lord. Without
Yes,
section
yes,
5 application, it cannot be done.
Very well. This is the appeal of 2010.
2010 and title suit of 1998. It's a premier property in Goriat. We could not get the position. They are not living here also.
My lord, our access has been locked.
Right.
Even the deities could not be.
No, I deny that. I deny that.
Not denied.
I deny that.
Kindly allow us to, in spite of our stay from this honorable court, they have done so.
No, I deny that. করেনি,
ঠাকুর টুকুর আছে কিছু জানতে পারছে না, লক করে দিয়েছে প্রমোটার কে লাগিয়েছে।
No.
আমার ডায়েরি কোথায়?
এখন প্রমোটার থাকলে সব হেলে যাচ্ছে বাড়ি না, প্রমোটার চলে যাচ্ছে।
শুক্রবারে কি ফিক্স আছে দেখুন? নেক্সট ফ্রাইডে।
বাংলা ছবি সব
নেক্সট ফ্রাইডে। সেকেন্ড আপিল কিছু স্পেশালি ফিক্সড আছে?
Lord, any other day, Lord,
I can do the
Friday.
second appeal only on Friday.
Lord, except Friday, because Lord, on Friday, before Justice Mantha, Lord, a review application is fixed next Friday. That's why Lord, I'm telling you, it will take some time, Lord, that's why.
Friday week আমার ওর
Second appeal. Okay. Please take down.
My lord, I'm paying for costs, my lord, in that.
Yes.
A 2010 appeal, second appeal.
তো মারা গেলে আমি
Not a single step has been taken to hear out the appeal.
Paper book is ready, records have called for everything.
Can 2 of 2024. This is an application for substitution on the date of respondent number 1. Full stop. Copy can is not in file. So one copy of can 2 of 2024 is taken from the learned counsel appearing on behalf of the appellant. এই একটাই can 2 of 2020 taken from the learned counsel for the petitioner. Let the can be taken on record. Full stop. Next para. Learned counsel for the petitioner applicant submits that respondent number 1 died intestate on 8th of April 2024, leaving behind one son and one daughter. Full stop. He submits that the present appeal is pending since 2010. After getting the information of the death of the appellant, the application was filed. Full stop. The learned advocate was absent. Learned advocate was unaware about the fact, as he was
We have communicated it to the learned advocate.
you have communicated.
Yes.
Yeah, next that letter, Lord. Letter of communication.
কি বললাম? Unaware about the fact, but the respondent has communicated the matter of death to the appellant. Consequently, the application was filed. He submits that there are some delay, though there are some delay in filing the application, but the instant application was filed. Though there are some delay in preparing the application, but the instant application was filed within 150 days. So necessary order may be passed, and necessary order for substitution may be passed after setting aside the abatement. Full stop. Learned counsel appearing on behalf of the respondent raised strong objection and submits that after the statutory period of limitation, according to the provisions of 120 of provisions of Article 120 of Limitation Act, the instant appeal has already been abated. Full stop. No application for setting aside of abatement has been filed. Thus, the application for substitution cannot be allowed at this stage. He further submits that the suit is pending since 1998. It's 1998, and
Suit is decreed
on 2010,
2006.
2006, appeal is 2010,
Lord, appeal, first appeal thereafter.
2000
First appeal because
suit
the
decreed in
decreed
decreed on
2006.
2006,
2006, thereafter first appeal, thereafter second.
2006, Thereafter, one first appeal was preferred, and now second appeal is pending since 2010. Now, second appeal is pending since 2010. He submits that the present respondent is suffering immense due to the pendency of the instant appeal. At this juncture, the appeal has already been abated, so the substitution petition cannot be allowed. Full stop. Having heard the learned counsel for the parties, also considering the fact that the substitution application was filed beyond the statutory period of 90 days. Full stop. 90 days. Full stop. It further appears that according to the provisions, the substitution and the application for abatement, application for setting aside abatement can be filed within 60 days from the date of abatement. In that score, the instant application is filed within 60 days from the alleged date of abatement. Full stop. It appears that the application, the appellant should have filed two separate applications, one for setting aside abatement and one for substitution. Full stop. On perusing the application being Can 2 of 2024, it appears that the appellant has prayed for substitution by setting aside abatement. Having heard the counsel, having heard the parties, it appears that the parties are ready for the hearing of the instant appeal. Considering the same, I think it necessary to allow the substitution so that the matter can be heard on merit. Full stop. Let the application being Can 2 of 2024 be considered and allowed subject to the payment of cost of rupees 2000. Cost of rupees 2000.
Within time, after
2000.
intimation, we have filed it.
2000 to payable by the appellant to the learned advocate for the respondent. Full stop. Let the matter appear in the list on disposal. Application in Can 2 of 2024 is disposal. Let the matter appear in the list under the heading of hearing. 7th of February.
My lord.
Everything is ready. Paper books.
My lord, my lord.
Have you served all the paper books?
My lord.
Okay.
Yes.
My lord, only one thing, my lord. May I just take back my copy and make a photocopy and hand it over to your lordship's officer? I'm grateful.
Next.
For the appellant, the matter is appearing under the we mentioned the instance of the respondent, but I'm led by
You are for the appellant.
appellant.
Who is for the
I am
respondent?
for the respondent.
My
They
lord,
have locked our access. In the
my lord, I am led by
In the
Mr.
meantime, Lord, kindly
Under the-
allow us to
No,
take out the DTs also. DTs is in the room.
What you see?
Lord, in the item number 1, they have locked the door. We cannot get access.
Then you have to file one application. Otherwise, how can I?
Then it will be delayed. If your lordship directs that, I shall take out the DTs and other articles.
No, they locked your. You are the tenant.
Yes, Lord, in absence, the main door has been locked.
Locked.
Yes. By some promoters.
So
They
you have been dispossessed.
not dispossessed. My room is there under my lock and key. But main gate has been locked by some promoters. I have been intimated. That is the problem.
You wrote a letter to the learned counsel. You know that. Okay.
In this matter, I'm led by Mr. Probal Kumar Mukherjee on the way.
What is your why you mention this matter?
I mentioned this matter, second appeal by them. For last nearly 18 years, the second appeal is pending. They are enjoying order of stay and injunction. No paper book,
The
nothing.
book has been filed.
Not been served on us. For last in an eviction suit, 18 years, no steps taken to get the appeal heard. Number one. Number two, this application, the appellant number 2 died long back. There's an application filed in December 2023. After substitution after a delay of 1500 days.
May I place your lordship?
Now, and that also filed and kept.
May I
December today we
May
are
I
in
be allowed to place my
2025.
application, my lord, in that event? Because
let him conclude.
no, my application, my lord, can too, my lord. I mentioned the matter on several occasions before the benches, my lord. The matter was not been listed, my lord. The copy was served. Now let me place my own application, my lord.
My lord, so far mentioning is concerned, we have not received a single notice. We mentioned once, the matter came in the list. So for last 1.5 years, this mentioning episode going on, matter is not coming in the list. It is
So what is the
Well, the
stumbling block? The
stumbling
application.
the application. So for the
Substitution.
so for the application is concerned,
Appeal is ready. The report is that.
Appeal is ready. Paper book has
ready,
been
paper
filed.
book
My lord,
has-
perhaps my learned senior friend is not properly. My lord, he has received the copy of the paper book. My lord, if he is not, my lord, I can.
no, we have not received the paper. We have not received the copy of the paper.
Or may I place?
Well, let
Paper
the
books are ready. It is the report. Paper books are ready. You appellants have not collected the paper book from the department as yet.
appellant has not collected.
The friend advocate for the respondent has filed. Respondent number 2 has filed 2 paper books. Respondent number 2 had filed 2 copies of paper books.
No, the
You have
vakalatnama. We vakalatnama.
They have said paper books.
Respondent দিতে হয় ভাই।
My lord, what happened?
Okay.
My lord, in
Report
this,
says you have prepared the paper book.
না, আমরা paper prepare করেছি।
No.
No, we have not prepared paper. We had 5 vakalatnama.
it's my change brief, my lord. So far, instruction I have received. The paper book has been. My lord, let the my lord, let us make a courtesy to this matter. My lord, let the appeal be heard out. I am also, my lord, eager on that, my lord. Let the application be allowed. A can too.
No,
my lord,
can
this was
cannot be
substitution.
allowed. There is a delay of
My lord,
1500 days.
may I place, my lord?
No.
You have filed any objection in this?
No. You will kindly grant me the liberty.
My lord, may I-
Because
If you want to file, I can file.
my lord,
But
will
that-
kindly.
my lord, appellant died, my lord. One of the appellant died. The relation between the
How
other
many appellants are there?
3
three
appellants.
appellants, 3 brothers. The second appellant died. The relation with the other appellants became strained, my lord, prior to his death. So there was no knowledge about, my lord. I have stated everything. If your lordship takes my application, your lordship will not find any lack of bona fide. Your
If they
lordship,
want to file objection,
lordship, kindly take my application, my lord, for once, my lord. My lord, from paragraph number 5.
memorandum of appeal, there are 3 appellants, Ashish Sen, Gautam
Yes,
Sen,
my
and
lord, my
Suhas
lord, my
Sen.
lord. Your lordship will find paragraph number 5 in page 5. Your lordship, kindly see.
Your can is can.
Can 2.
Old can. Can 2.
Yes.
Can 2. Can 5883. Of 2005.
My lord, can 2 of 23. Your lordship, kindly,
Can 2 of 2023.
your lordship.
Can.
Is it there?
Old can.
একটা extra copy আছে।
Can গুলো রাখেন না কেন ফাইলে?
কি ক্যানের কপি নেই?
May I give my copy? I have extra copy.
Just let me find it out.
I have a copy with me, my lord. It can.
না can গুলো কোথায় চলে যায়? Give me a copy. বের করুন।
Just you kindly take page 5, para 5. That during pendency of the said appeal,
Yes.
during pendency of the said appeal and the application for injunction, the appellant number 2, namely Gautam Sen, died intestate on 30th of August 2019, leaving behind his following heirs and legal representatives. The death certificate I have annexed. That all the above named heirs and legal representatives of late Gautam Sen are major and sui juris. That since last 2 years before the death of the Gautam Sen, the relationship between the applicants herein and their full-blood brother Gautam Sen becomes strained due to some difference in opinion on some family issue. The applicants herein have no connection with Gautam Sen and his family members. As a result, the applicants herein had no knowledge about the death of their brother Gautam Sen till April 2023, and they came to know about the same from their one common relative on April 28, 2023. Then, after much effort, the applicant obtained a copy of the death certificate of late Gautam Sen on September 29, 2023 from the said relative, whereupon the applicants for the first time came to know about the death of their brother Gautam Sen on 30th of August 2019. The applicants thereafter sent message on several occasions through some common friends and relatives to the legal heirs and legal representatives of late Gautam Sen, seeking necessary instruction and cooperation from their end to enable the applicant's hearing to substitute late Gautam Sen by his heirs and legal representatives, but no response came from their end. That after waiting for more than 2 months, the learned advocate on record of the applicant's hearing issued a notice by registered post with acknowledgement due to the heirs of the legal representatives of late Gautam Sen on December 7, 2023, requesting them to give necessary instruction within 7 days of receiving the said notice, disclosing the stand they want to take in the said appeal after the death of late Gautam Sen. According to the track consignment report, the said notice was delivered to the heirs and legal representatives of late Gautam Sen on 11/12/2023. The heirs and legal representatives of late Gautam Sen have not responded till date despite receiving the said notice. That due to the reason as stated above, the applicant's hearing could not substitute the heirs and legal representative of appellant number 2 Gautam Sen after his death within the period as prescribed under Article 122 of the Limitation Act, that is on or before 28/1/2019. As a result, the said appeal has already been abated as against the appellant number 2, namely Gautam Sen, after 28 November 2019. The applicant's hearing could not file any application for setting aside abatement within the period prescribed under Article 121 of the Limitation Act on or before 27/1/2020 due to the same reason as already averred in the foregoing paragraphs. As a result, the delay of 1483 days has been caused beyond the period prescribed under Article 120 of the Limitation Act, and 1423 days delay has been caused in taking out the application for setting aside abatement occurred due to not substituting the heirs and legal representatives of deceased appellant number 2, namely Gautam Sen, and the same unless is condemned, the applicant will suffer irreparable loss and injury. The heirs and legal representatives of late Gautam Sen, that is appellant number 2, whose names and particulars have been stated in paragraph number 4 herein above, are necessary and proper parties in this appeal, and no effective adjudication of the dispute involved in the instant appeal is possible without implementing the said heirs and legal representatives of late Gautam Sen in the array of parties in the memorandum of appeal. As such, unless the instant application is allowed by this honorable court, and thereby the heirs and legal representatives of late Gautam Sen, that is appellant number 2, is substituted in place of Gautam Sen after setting aside abatement upon condonation of delay of 1483 days, after the expiry of the period prescribed for taking out the application for substitution, the applicant's hearing shall suffer irreparable loss and injury. Now, your lordship, can you take my prayer? Paragraph number 17, my lord, your applicant states that the heirs and legal representatives of late Gautam Sen and the appellant number 2 are not extending any cooperation to the applicant's hearing to get themselves substituted in place of late Gautam Sen. Therefore, unless a further order is passed by this honorable court to implement the said substituted heirs and legal representatives of this is appellant number 2 as performed respondent in the memorandum of appeal, the appellant will suffer irreparable loss and injury. In the premises, as aforesaid, your lordships may be graciously pleased to pass an order allowing this application for substitution of the deceased appellant number 2, namely Gautam Sen, who died on 30th of August 2019, by his heirs and legal representatives named in paragraph number 5 of the instant application after setting aside abatement as against the said appellant number 2 upon condonation of delay of 1483 days, and also to implement the legal heirs of the said appellant number 2 as the proforma respondent in the array of parties of the memorandum of appeal of SA 16 of 2012 and pass such order. Now, how more bona fide I can show, my lord? This is the application, my lord. Everything, my lord, has been explained. My lord, if you
one application, you file substitution,
my lord, it can be, my lord, it can, my lord, if your lordship, my lord, that can, my lord, if your lordship says I can pay the deficit code, my lord, that can be prayed, my lord, because it's a same, my lord, reiteration of same pleading would be required, my lord, if I file another application. The my lord, ground is common, my lord.
Lordship, so far, 2-3 applications coming up, Lordship, I'm not, there's technical between the court and him, court fees. I'm not on that. It's for the fiscal problem. Now, today, what is evident from his pleading, that the legal heirs of the deceased are not interested. That's evident from his pleading. He has contacted whatever, then he is not interested. But the appeal won't abate because the other heirs, appellants are there. Now he wants, as they are no more wants to join as appellant, no interested, he wants to add them as a pro forma respondent. Now, my question is whether this can be done. In the parent suit, they were the defendant, they were the appellant. Now, can somebody become a pro forma in appeal, second appeal? Let the appeal continue without the legal heirs of Gautam Shen because legal heirs are not interested. You give a different if one's a plaintiff, defendant or an appellant.
Opposition.
Yes, my lord.
Then
Because if the legal heirs are not interested, let them not continue with the suit. They are not coming in. But to make them as a pro forma respondent, because legal heirs are not interested, why the other appellants want to drag him in litigation?
But I can just, my lord, subject to what my learned friend
No,
says,
whether
my lord,
you want to
explain.
use the opposition.
My
I
lord.
can allow
In
you.
this
Otherwise,
application, my lord,
I
I tell your
will.
lordship, my lord, there's no need of my lord filing an opposition. Why I say? My lord, there is a necessity of a substitution, no doubt about it. Now,
no,
my lord, the
how
question,
so many days delay?
now, my lord, so far as my lord, the delay is concerned, my lord, that my lord, we have tried to explain it here. Now, my lord, the other question is, my lord, my learned friend says that whether, my lord, on substitution, whether, my lord, they can be transposed as a, my lord, a respondent. If somebody is unwilling to come before this court as an appellant, Lord, I have no other option but to transpose Lord as a respondent because there is a necessity of substitution. That cannot be Lord denied. Now, Lord, on substitution, if they are not arraigned as a Lord an appellant, then Lord, only option is Lord to arraign them as a respondent. So I do not know where my appeal doesn't abate because there are other appellants. The question is not the heirs of the deceased, not the appellant number 2, whether not they should be arraigned as a party respondent or not.
Actually, who are the
But they're the heirs of
The-
not the
the
deceased
landlords.
appellant number 2.
I am the landlord.
who are the landlord? They are the
Yes.
tenants. They are
They are
residing-
three full brothers.
the three full brothers.
They are full brothers. As they're pleading, they are full brothers. Now, 1500 days, 1400 odd days delay. And
Okay, you use your affidavit.
yes, it's only deletion of the name. Substitution may not be required. It's only deletion of the name. Yes. The suit cannot present a dead person. It's only deletion of the name.
CPC. But your lordship will kindly, my lord, take order 22 for once. My lord, I'm answering to my lord, my learned friend that substitution, my lord, is not required. Deletion of name is required. I'll be only answering, my lord, on the legal point that my learned friend, my lord, has taken. But if your lordship kindly take some, my lord, order 22, my lord, for once.
CPC to the
এটা দেখো এত দূরে রাখবো বিধি এটা বললাম যে সুযোগে বাবাই হয় না But order 22, rule 3.
yes.
Blood where one of two or more plaintiff dies and the right to sue does not survive the surviving plaintiff or the plaintiffs alone, or a sole plaintiff or sole surviving plaintiff dies and the right to sue survives, the court on an application made in that behalf shall cause the legal representatives of the deceased plaintiff to be made a party and shall proceed with the suit. So, my lord, to make a party, my lord, that is, my lord, statutorily ordered. So, my lord, whether he is arraigned as a party appellant or a party respondent, but that is not spelled out here. But in the given circumstances, when they expressly say that I do not execute a vakalatnama to be arraigned as an appellant, I have to arraign them as a party respondent. My learned friend's contention that they should not be arraigned as a party is, my lord, it belies, my lord, the interdictum of, my lord, the rule 3 of, my lord, order 22. Then, my lord, 2, which is not the question here, where within the time limited by law, no application is made under sub-rule 1. The suit shall abate so far as the deceased plaintiff is concerned, and on the application of the defendant, the court may award to him the cost which may have incurred in defending the suit to be recovered from the estate of the deceased plaintiff. So, my lord, in these circumstances, my lord, when I have made the prayer, my lord, your lordship will kindly come to internal page 8. But your lordship knows, my lord, that a composite application, my lord, is maintainable in a case of a substitution along with condonation of delay. I don't have to take out a, my lord, there's a division bench judgment to that effect. But we all know about that. That's the reason, my lord, I'm not bringing and assisting your lordship with that judgment. So this prayer was, my lord, for a condonation of delay and for substitution. Now, my lord, if my learned friend says that, my lord, there is a, my lord, if they want to object on the point of limitation, they have a right to
Prayer was
object.
not there regarding condonation of delay like that.
But so far as substitution, my lord, they do not have any defense. On a condonation, if they say, well, my explanation is improper, they have a right to object.
An application is not within time. So they may have raised question, no issue.
So, my lord, we have, after setting aside the amendment as against the said upon condonation of delay. So these composite applications in the appellate side, my lord, we generally do that.
Yes.
Because we don't have to take out 3 applications here. One
No,
for
no,
substitution, not
necessary,
for
but
setting
one
aside
prayer is
amendment or for.
required. You have not made a
Yes,
single
yes, my lord,
prayer
prayer is there.
for setting aside amendment. You have made a prayer,
Prayer is there.
but delay condonation prayer is not there.
Yes, upon condonation of delay 1/483 days. The second last line of the prayer.
Upon condonation, last.
Last
Yes.
2 lines, last 2 lines.
But these are the, my lord, the general, my lord, your lordship has experience, my lord. We, my lord, file this type of applications, my lord, in the appellate side.
No, that is not the issue. Here he is saying that your brother is not at all interested. So why the right to sue, whether right
But
to sue is-
interest and right to sue, my lord, it is a different concept altogether. Not a person may have a right, but the person may not choose to have the right enforced. My lord, that is one thing. But I am obliged, as my lord, the remaining appellant, my lord, to cause a substitution. Under Order 22, Rule 3 in this case. Now, my lord, I have got the names of the legal heirs. The legal heirs, they do not, my lord, want to come in the array of, my lord, the appellants here. So the only option, my lord, they can be arraigned as a respondent, and that to a pro forma.
Yes.
So far, this application is concerned, there is a delay of nearly 1483 days, my lord. My
Only-
prayer is before lordship is
Only.
only, my lord, will give me liberty to file a objection to this application or for this enormous delay, and whether the explanations, I'll deal with everything, whether they have a right to sue survives or they can be transposed as a pro forma defendant respondent in the second appeal. I'll deal with them. Yes. 18 years have gone, no steps taken to get the appeal heard.
But I am not shying away. If
Again-
your lordship, my
again
lord,
it would be
fix the
delayed.
appeal for hearing, my lord, I can.
It should be, man. It is for a month. If I've waited for 18 years, man, I'll do it in two
Very well,
weeks.
very well. I can allow you to file
2 weeks time. man.
opposition. Opposition within 1 week.
My lord.
No. No. Can do better. কোথায় থাকে? আছে না মানে? এখানে কে রেখে দেয়? লিস্টে হয়ে গেছে কেন আসবে না মানে? কেন থাকবেন তো হয় নাকি? লিস্টে রান করছি কেন?
ক্যানটা নিয়ে আসেনি?
ওগুলোর কাছ থেকে
এ বাবা।
কি এইভাবে চলে নাকি? ক্যানগুলো ঢোকাবেন তো? Can 2 of 2023. The can is running in the list.
না, অ্যাপ্লিকেশনটা লিস্টে নেই। দিয়েছি।
The can is not in the
Can
file.
do.
লিস্টে?
Let a copy of the can be taken up from the learned counsel for the appellant. For the purpose of hearing of the instant can, full stop. The learned counsel appearing on behalf of the respondent intends to use opposition against can 2 of 2020. Let the opposition be filed within 2 weeks from
1 week.
1 week. from date.
1 week.
Let the matter appear in the list. Let the can application
A reply, my
appeal
lord,
in the
within
list.
1 week thereafter.
reply. Acha.
Yes.
Reply within 1 week
Don't
thereafter.
reply anybody.
Let the matter appear in the list on 14th of February
Lordship.
under the heading application.
Yes. Now, my lord, I find, my lord, from the paper book, my lord, that the paper book was prepared, my lord, at the office of the respondent, and my lord, it was already, my lord, filed on record. So, my lord, it
So
was
we
the
have a-
respondent who had prepared the paper book, and my lord, I am not shying away from hearing of the appeal. Your lordship may any day hear the appeal. It's not that, my lord, that
Come on
because
that
of,
day.
Yes,
Come on
on
up,
for the
14th February.
shelter of, my lord, an application, I am shying away.
14th February will come and
14th February you come.
Lordship,
একটা copy নিয়ে নি।
14th February তুই আসতে পারবি তো? দেখিস বাবা।
দেখে নাও বাবা। Well, we won't fight on 14th February.
Yes.
That's a whatever.
Yes.
He will be busy on that day, my lord. He has a better job to do. Great.
Obliged.
Thank you. Next. Yes.
Today, I'll be pointing out the relevant part of the judgment of the appellate court, reversing the degree of the trial court lot. Based on the finding of facts from the paper book, your lordship will kindly see page 25. The relevant part I will be pointing out. Therefore, I shall the decision on the based on the points. There would be further options. In the paper book, Lord, but I am the defendant in the suit, respondent in this appeal, Lord. In the trial court, I know appeal court is succeed. This is against the order of reversal of filed by the
Yes.
plaintiff appellant.
আর কোথায়?
And to the
রেকর্ডটা দিন। বাকি রেকর্ডটা দিন।
'52.
পুরোটা আছে। কোথায় পেপার বুক কোথায়? কিছু নেই। আমার নোটিং ফোটিং কোথায়? পেপার বুক আছে তো। নিচের পুরো এন্টায়ার ম্যাটার।
I but with my kind, my friend may be permitted to place the judgment, then I shall be taking up the matter. In conclusion, I am with my friend.
Yes.
Kindly permit me, my friend, to read out the judgments, then I shall be taking over the matter. That's the conclusion. I shall continue. I am here. I am here.
No, you are appearing for?
I am appearing with you, respondent.
Okay. No, We have now dealing with the facts.
Very good. That's why Malana say, man, that my friend knows fact better than me.
Yes.
So let me,
Let him conclude first.
I will be here.
Yes. You sit, please.
ঠিক আছে।
Got the paper book?
Yes, yes. Mental computer.
Okay, you can proceed.
You also got the paper book?
No, give me a copy of your paper book.
Yes, I am giving it.
কোথায় নিয়ে যাও কেন? এগুলো হিয়ারিং এর রেকর্ড আলাদা করো কেন? কিছু বুঝতে পারা যায় না। এটা পাঠার চলছে, সে রেকর্ড টাচ করবে না। কেন টাচ করো কেন? পাঠার রেকর্ড। I've got it. Give me the paper. পাঠার রেকর্ড টাচ করবে না এখন। যেরকম আছে সেরকম থাকবে।
In the paper book, page 25.
Page 25.
25.
Yes.
Second paragraph. Practically, got it.
Yes.
Practically, after considering the exhibit, it is found that the plaintiff Sorosirai executed deed of sale on 17/4/1985 in favor of Govind Ghosh, by Exhibit A in favor of minor Opores Ghosh, by Exhibit A1 in favor of Gaurori Ghosh, by Exhibit 2 and in favor of Alokesh Ghosh, by Exhibit 3. And these 4 deeds are the subject matter of the suit, which are described in procedural property, and in the procedural property, the Jivan Shatto deed is the subject matter, i.e. Exhibit D in this case. So the main question is whether Sorosirai is known fully well on the contents of the disputed deeds, Exhibit A to Exhibit 3, which are executed on 17/4/85, are genuine deeds of sale or not. But considering the plain case, it is clear that she went to the registry office, put signature, knowing everything correct. But her claim is that she executed it knowing that it was Ammuktar Nama. But main question is whether any consideration money was passed or not. But in this regard, after considering the argument of the learned lawyer for the appellants and the respondents, it is found that the learned lawyer for the respondent failed to give any satisfactory explanation on the ground that in all the deeds on the back page, when the registrar asked the present plaintiff Sorosi Debba whether she executed any documents, she admitted the execution of the documents. Not only that, in all the deeds, there is endorsement that in respect of Exhibit A, Sorosi Debba received 7,000 rupees in presence of the registrar, and the registrar noted it, and similarly in respect of A1 received 5,000, and in respect of Exhibit 2 received 7,000, and in respect of Exhibit 3 received 6,000, and there is specific note of the register that Soruchi received it in presence of the sub-register Jhargam and admitted the execution. From the body of the deed, it is clear that the total consideration money of the 4 deeds were passed. Soruchi Debba received it in presence of the sub-register. Sub-register noted that consideration money. When on the last occasion, I have submitted the endorsement made in the back page of the first page of the deed.
Yes.
Thereafter, the registrar asked her whether she admit execution, and she admitted it, and to that effect there are notes. And if there is, if that is the fact, then how the court go beyond this note when registering authority at the time of execution tried to convince herself that consideration money was passed or not, and also asked the lady whether she admits execution, and she admitted in and considering that parts of the deeds, it is clear that in respect of the disputed deeds, as described in the Schedule 4 to 3, consideration money was passed, and there is no ground to disbelieve that that fact in view of the fact that there is note on the register on the back page of the first page of the deeds, i.e. Exhibit A2, A3, that consideration money was passed. Similarly, she executed it after accepting money, i.e. consideration. Then she admitted before the register that she executed the deeds, and she personally was present before the register office, which is proved, and it is also admitted in the claim that the plaintiff went before the sub-register and admitted the execution. Then what more is required for registration, and what more is required for believing that the lady appeared before the registering authority, admitted the execution, and receiving consideration money, and then there is no ground to disbelieve that the deeds were otherwise prepared. Rather, the deeds itself support that sale deeds were executed by Soruchi Debba after accepting consideration, sum of rupees 7,000 in 2 cases and 5,000 in 2 cases in 4 deeds. In 2 deeds, 7,000 each, and in another 2 deeds, 5,000 each.
What is the total consideration money of 4 deeds?
4 deeds, total 25,000.
Give me the deed.
1,000 was given
LCR.
at the time of
Total LCR to the
total agreement, and the rest 24,000 has been given before the register. In every deed, the first is backside.
Yes.
Well, the first page backside you also got it. Rupees 7,000 only as consideration money paid in my presence by Govindo Prasad Ghosh to Soruchi Debba. Signed by the witness.
Yes. So what is your submission? This is the fact. I know that fact.
The next portion I am submitting, there I will come.
Okay.
Page 27. Another factor is that Soruchi was not illiterate lady, which is evident from the handwriting of the lady, and also considering her appearance before the registering authority, her answer before the registering authority regarding acceptance of money. Now the question is whether after purchase the properties were recorded or not. From the LR record, it is clear that the names of the purchasers were recorded in the LR record. As per provisions of Section 50 of the Land Reforms Act, upon production of the registered deeds, their names were mutated, and accordingly, the ROR was prepared. From the LR records, Exhibit E series, it is clear that the names of the purchasers were recorded in the LR record. Considering the sale deeds, and the LR records, Exhibit E series, it is found that Govinda Prasad Ghosh, minor Apores Ghosh, Gaurhari Ghosh, and minor Alokesh Ghosh purchased the property by giving good consideration in the year 1985, and they are in possession, and land and LR records support their possession. And considering the plain case, it is clear that there is a good relation in between the plaintiff and the defendants. Defendants always looked after her, and as per defense story, for her proper protection, they, on behalf of minor Apores Ghosh, Jibon Satto deed was executed on 22nd April 1985, 4 days after the execution of the sale. And regarding Ghosh property, the life estate deed executed on behalf of the defendant, Exhibit D, cannot be declared void in view of the fact that the deeds as described in the procedural are valid transfer, and there is no question of non-passing of any consideration in respect of the given subject. Rather, the consideration was passed, and fact remains possession was also delivered, which is also proved from the LR records. But the learned lawyer for the respondent submitted that the court rightly searched out everything and came to a conclusion that he was illiterate. In fact, Soroshi Debba put her LTI at the time of her deposition, and it is the common practice that when a deed is executed by signing, she put her LTI in the WS or in the deposition sheet to show that she is illiterate. On the other hand, the deeds are proved by the deed writer, and other witnesses, also the signature of the plaintiff.
But the deed writer appeared. Deed writer never appeared. One person from registry office, who is a staff of the registry office, appeared to certify the registered deeds.
Yes, and so far the deed writer
Deed writer never appeared. So why such a observation is that the deed writer proved the deed?
Well, this is the finding arrived at by the learned court below, based on the finding of fact. It is the common practice that when a deed is executed by signing, she put her LTI in the WS or in the deposition sheet to show that she is illiterate. On the other hand, the deeds are proved by the deed writer and other witnesses, also the signature of the plaintiff. That all these deeds are exhibited and it's a 1 to 8. Most peculiar factor is that plaintiff most peculiar factor is that in the plaint, Soroshi Debba put her signature. In the plaint, she put her signature, whereas during evidence, Soroshi put her LTI, and the learned court believed that she is illiterate lady and she never signed in the deed and declared the suit. Considering the evidence of the court, including the peculiar factors stated in the plaint, it is clear that the plaintiff has admitted that she appeared before the registered executed the deeds, knowing fully well that it was not Ammuktanama or power of attorney. So in the plaint, she had admitted that she executed the deeds and it was signed by her. But during evidence, she put her LTI only to show that she is illiterate, and this is an attempt to prove her illiteracy, but she is not illiterate. Handwriting says so. But the style of the signature will prove whether the person is illiterate.
This is not a good observation. How can a signature can be verified to be a literacy or illiterate?
Sometimes it is saying that an illiterate person can put only his signature, but that signature must not be tallied with the person.
No, this argument cannot be considered. There is no instances. Rather, there are evidences. Evidences that I cannot read and write. But there is no such cross-examination. In cross-examination, he said, positive question and positive answer, I am illiterate.
Fact remains that the style of signature of the persons.
No.
But
Court is not expert. Court has no materials to suggest like that. Court cannot opine like that. By styling a signature, you can say you are an expert of knowing the signatures and the person.
in the deeds as well in the claims. And
No, this is not a good observation. You know, this is not a good observation.
in any way, my lord,
Yes.
It is the attempt to prove her illiteracy, but she is not illiterate, and writing says so. So, admittedly, deeds were executed. Then, invariably, one deed would be found, but 4 deeds were executed, and in 4 cases, Sorji Deva received consideration amount, i.e., in 2 cases 7,000 each, and in 2 cases 5,000 each. Note of the register is there that Sorji received it in his presence and then admitted execution of the deed. Then it was registered. So regarding the disputed deeds, there is no ground to believe that the deeds were procured by the defendants by any means. Rather, in the year 1955, more than 25,000 were paid. And it was paid by the defendants, and good consideration money was passed. But the story of executing Muktanama on good faith, relying upon the defendant, is proved completely a bad story. Rather, it is a false story. Defendants have rather proved their case that the suit property was purchased by them, and therefore by Exhibit D, they granted life estate, and for which the plaintiff has been residing in that house, which is also proved. But considering the judgment of the learned court below, it is found that the learned court below did not consider the legal aspect, but the learned court below discussed in the judgment about illness, ill health, condition, etc. So in respect of that, there is no material within the record, but that chapters should not be considered in this case in view of the fact that the plaintiff herself admitted before the register about execution of the deed, and further fact is also proved that consideration money was passed. Sorji Deva received it in presence of the register, and register noted it. Regarding possession, no doubt, on the basis of the exhibit, the plaintiff is in possession, but it is her life estate. So, considering that fact, it can safely be said that the plaintiff's possession cannot be disturbed. So long she is alive, but in respect of the suit property, defendants have right, title, and interest, and possession is through the plaintiff, and on the death of the plaintiff, invariably defendants shall get possession. No other persons has any possession except the plaintiff on the basis of the executive deed and given so. So, in the light of the above observation, I am convinced to hold that the defendants have proved their right, title, and interest over the suit property, and their possession is through the plaintiff, and the plaintiff's possession in the suit property is nothing but a life estate possession on the basis of the exhibit D, and no other persons has any right, title, and interest except the defendants. And after relying upon the above facts and circumstances, including the finding, I am convinced to hold that the plaintiff's case is proved a false story. Plaintiff has no right, title, and interest over the suit property, but plaintiff has her life estate right in respect of the property on the basis of the exhibit D, and on her death, defendants are the absolute possession of the suit property. In this result, there is sufficient ground to allow this appeal and to set aside the judgment of the learned court below. Order accordingly, my lord. The suit be and the sale is dismissed and contest with cost against the defendants. Further, it is declared that as per prayer of the defendants, the defendants have the right, title, and absolute interest over the said suit property as described in civil property. It is declared, and the deeds as described in the civil co 2, co 3, and go are valid and genuine deeds and genuine deeds. But the plaintiff has a life estate right in respect of the disabled land and property as life estate right, and defendants have their absolute constructive position over the suit or over the suit procedural property.
Where is the player?
So where is the prayer? The consequence of
Kiসের prayer?
prayer. Prayer. যেখানে প্রেয়ারটা কোথায় তোমার রাইট ডিক্লেয়ার করলো, প্রেয়ারটা কোথায়?
আমি তো ডিফেন্ড
বলুন আপনি।
হয়ে গেছে তোমার বলা?
হ্যাঁ হ্যাঁ, প্লেস করে দিয়েছি জাজমেন্ট।
With the my lord's permission, I may click over.
Yes.
But I shouldn't waste my lord's time by repeating what has been already told by my friends and my friends. Facts, my lords, that I will appraise in the mind of your lordship. The only thing is that we know that in case unless the pain and the brain acts together, there is no valid execution. Or that means unless there is a conscious execution, it is not a valid document. That's the basic thing. So that is the only ground.
The only ground in the appeal is very small question. The second appeal was admitted only on the ground that if you know whether the learned first appellate
I've seen my
you have gone you have yes whether
That is-
learned first appellate court has correct to on the view
course.
in respect of the
Reversing
illiterate lady, whether they have taken the point of illiterate lady and execution of illiterate lady is correct. This is the only question in the second appeal. I have know the entire fact.
Right, absolutely right. That is the only point taken for substantial question of law.
Yes, only substantial question of law.
That is the pivotal of the entire matter. Now the question is the only thing I kindly appreciate. It is clear, it is true that the law is well settled that for the non lady or the illiterate special cloak is there, special protection is there.
Yes.
But my respectful submission is that this is the only turning point. That protection is not an absolute thing. If it is found from surrounding circumstances that the he or she had the understanding of what he or she is doing, then that the protection is regulated and curtailed to a great extent. Here in this case, Lordship kindly appreciate the facts are well appraised in the mind of your Lordship. But I shall not repeat what has been already told. I shall try to be very brief in my
Yes.
just the points. Now, kindly see. My lord is of the view that illiterate means he has taken the literal meaning of the being illiterate. But the fact remains that she has put her signature in the deed, in all the deeds. It is nobody's case that she was forcibly taken to the registry office. It was not a registration on commission. She had going to the registry office, executed the document and signed it. So he is not illiterate in the sense that she can write and read and write these basic things. Though she is not she may not be a qualified person to understand everything or the impact of the deed was in Bangladesh. It was in Bengali language, and admittedly she put her signature in 4 deeds. And that's why, and that was done in presence of the registrar himself. And the consideration money of the question is, my lord, the very significant thing is that if it is the fact, if it is the case of the plaintiff, that in the garb of different power of attorney, settled it has been taken. Well, there are judgments in support of this case of the plaintiff in 1958 Madras and then 1956, 68 Supreme Court page 5, 956. that unless the pain and the brain acts together, unless the person executing the document knows what he is doing or she is doing, it is not a valid document. But here they kindly appreciate here. If it is a power of attorney, then the question of consideration money, how will it arise? And she accepted the consideration. There are no explanation here. Protection for illiterate person is there in the statute. But that is not an absolute protection. Because here in this case, he says that in the name of power of attorney, deed has been taken. 4 deeds have been taken. Now, why the consideration money? Power of attorney for execution of power of attorney, consideration money is not required. No explanation has come in this regard.
Yes.
Another thing is that it is nobody's case of threat or coercion because another deed, Amoktanama for giving live estate was done. She again went to the registry office. Not that she is unknown or otherwise or not familiar with the registration purpose. So that shows the bona fide, the positivity of the present dependent.
Whether in case of the live estate, she was in the registry office? No, she was not in the registry office. In case of the deed of live estate, there is no requirement to go to the registry office by.
I follow my view. And the fact remains the registered document is there. Public document is there and that is unchallenged till now.
What benefit of that?
So that shows
No,
that
they have plenty have challenged the deed also, but no evidence was laid by the defendant to contradict the challenge. Nothing.
question is that Lordship
In case of, I understand, in case of sale deeds, there are some persons of the registry office to say these are the original registry office and these are the original signature of the registrars. But in case of a live estate deed, that is a term of deed like that, there are some other requirement to prove, not the register office by register deed.
my lord is absolutely right. But that is a matter, that will be matter of record. I should not say anything beyond record. But the record says that whether she was getting the benefit of the outcome or not, or she is in possession thereof. Now the question is that another thing is that the court has held about the consequential relief. Question is that if by deed, the deed there is a affirmation, on deeds the affirmations are there. গ্রহণ করিয়া সম্পাদন করিয়া the খাস দখল দিলাম. The affirmation is there also in these deeds. So to counter those deeds, the appropriate evidence has not come before your lordship, before the learned judge. Because the fact remains, the 4 deeds were not challenged before 12 years. And she has started to make out a knowledge from the BLR office. The fact remains, the settlement record is in the name of this my clients. That is that indicates the possession is with my clients. There is no prayer in the claim that the record of right is erroneous. Pilot knows 57B and 69 2A. Sorry.
Correction of record of right is not the ambit of the civil code also.
No, that is
also
I'm grateful for posing this question. A full bench is going on. I had the privilege to address the full bench on this question. But I am trying to press up in my humble way with my little knowledge about the distinction between the two.
Yes.
57B says civil code is the only authority to declare the power of attorney, a record of rights is correct or not. The duty of the code stops. The correction cannot be done by the civil code. My is absolutely justified. That is 44(2)A and the 51 of the Land Reforms Act. But the question is that the record of right is erroneous. This prayer is required. And that indicates because that carries with the question of possession. If she is not in the possession, then she is consequently she is to pray for recovery of possession. Rightly, wrongly, if the lady is not in possession by pursuant to the 4 impugn deeds, then she is to say, pray for that the decree, the recording of the name of the plaintiff, my clients in the record of rights is erroneous. After that, civil court cannot correct it. Absolutely not. That prayer is not there. Because that touches the question of the other thing, recovery of possession on a payment of advance court fees.
Yes.
That prayer is not there. That is the lack of a consequential relief. So, my lord, I should not repeat. I should not repeat as to what was my friend has already read out. I may humbly invite my lord attention to some relevant pages only.
Yes, proceed.
I invite lordship's kind attention. Only my lord, I shall be taking here only the relevant portions only. Running page 29, inner page 25. Of judgment.
Judgment of first appellate court.
Yes. I will kindly consider the paragraph of the, but considering the plain case. This paragraph, kindly I appreciate this paragraph.
Page,
Running page 29, inner page 25. In my copy, my lord, subject to correction, my lord. Fourth paragraph, last paragraph.
yes.
Last paragraph, but consider that one can consider this paragraph.
But considering
Got it.
May I place it?
considering
Last paragraph, good. But considering the plain case, it is clear that she went to registry office, put signatures, doing everything correct. But the claim is that she executed it knowing that it was a Mukta. Another thing is that lordship. My lord knows better than me that in case of power of attorney, registration is very optional. Excepting in a case where power of sale is given, it must be registered before the registration of the authority. Section 32 of the Registration Act. So, had it been a registration where no sale power is given, because he herself is selling it, so why the registration is necessary?
No, the question is when it was pleaded before the court of law regarding the ignorance, regarding the misrepresentation of a lady. So you cannot deal with the fact of the legal aspect that the lady has the knowledge of the legal aspect. You have to consider the entire facts and circumstances
Of course,
under the scanner, under the floodlight.
of course.
There are some questions.
Because we
Why the relation as mentioned in the plain case was not actually denied by the defendant regarding the palito ma like that.
the question
How such questions arise
minor
after?
is absolutely justified. The court or we cannot go beyond the record.
Yes,
But the question is that lordship, we have to kindly appreciate, my lord, to construe the entire thing. What is the probable explanation?
yes, only the probability we can understand.
Then another thing lordship kindly appreciate. But I kindly bear with me, my lord, for a few minutes. Next page, which I am shown. Page 26, inner page 26, running page 30.
Yes,
Then the kindly see the exhibit A discussed, other exhibits discussed. regarding the payment of consideration money and how it was paid. Registration officer is a registry officer, is a public officer, discharging his official duties. In course of his official duties, he has made some endorsement. There are some illegal consequences. He is a disinterested person. She has told implication of what would be implication, my lord will consider along with other materials. But the question is the registrar of the registry office is a public officer discharging his public function, and what he has stated the consideration money was taken in his presence without any demand, without any reservation. Next,
Now, if we go to the if we proceed to your argument on that point, if we think that yes, some consideration money was passed in presence of the registrar. So if the fact is the nut of the matter, so the fact has to be proved by the defendant by placing some evidences. There are 4 witnesses for such transfer of money, and the registrar personally not appear before this court. One staff appears saying that this is the signature of the registrar. But there are some other witnesses, local witnesses, who are alive.
But at the time of registration, it was in the registry office itself. So the public officers were there of the staff.
Public officers are there.
No
some
local
witnesses are there. Read writers are there. Everyone is there.
But I do not know because well, kindly
Why
permit me.
such witnesses are not come to say yes, money was transferred.
Kindly permit me to read few lines.
Yes, please.
Few lines from few places without wasting my lord's time. Next is thereafter, after a middle portion, thereafter, registrar asks her whether she admits execution, and she admitted it, and to that effect there are notes. And if that is valid, an impartial officer made an inquiry and she was satisfied and made a discharge his official duties by accepting it.
Made the endorsement.
And if that is the fact, then now the court can go beyond this note when the registering authority at the execution tried to convince herself that the consideration money was passed or not, and also ask the lady whether she admits execution, and she admitted in considering that parts of the deed. It is clear that the invested disputed deeds as described in the schedule court to 3. Consideration money was passed and there is no ground to disbelieve. Now, my lord, after 2-3 lines. Similarly, the executed it after accepted money. Then that is to say consideration. Then she admitted before the registrar that she executed the deeds and she personally was present before the registry office, which is proved and is admitted in the claim. Then, my lord, then page 31, running page 31, inner page 27, second paragraph.
Yes.
What is the understanding of the judge in the court below? Another factor is that Saroshi was not illiterate lady, which is evident from the handwriting of the lady, and also considering her appearance before the registering authority, her answer before the registering authority regarding execution, regarding acceptance of money. So their observations are there, and by no less than a responsible officer of the government.
Now, how can a court come to the know about the literacy of a person
In the sense,
by seeing the handwriting?
well, rightly or wrongly, it is our normal impression in the day-to-day life is that সই করতে পারে মানে নিরক্ষর নয়.
No, that is not the case.
That is
there are several instances.
She may not be equipped with the details of the other.
Not details. Every person you can arrange in a gram, in a village, you can see 80% people cannot read and write, but they can sign properly.
I kindly appreciate along with the surrounding circumstances, the relationship between the parties, understanding between the parties.
Relationship between the parties, whether defendant admit it not. If defendant admit, then defendant fails. That's why they has not
Well,
admitted.
they
But
are-
later stage in the appellate court has admitted the relationship. How? Defendant never admitted such relationship.
Now, the next question is, Jivon Sattva was executed and she was permitted to occupy the premises.
Why after 4 days? Why after 4 days of execution of the deed?
For further for request from the plaintiff for further protection on our part. Because the rest of the right. And next, my lord, very significant thing, my lord, to be very frank, I have not read the entire deposition of deed writer.
Okay.
My lord, kindly come to page 32, page paragraph, inner page 28. Turning to 32. Paragraph starts with, but the learned lawyer for the respondent submitted says that submission of the learned lawyer.
Submission.
Then last 2 lines of that paragraph. On the other hand, the deeds are proved by the deed writer.
Why? How deed was proved? There is no such witness of deed writer or other witness. No one appeared before the court.
4 witnesses are there, the deed writer was not.
No one appeared before the learned trial court to prove the deed.
And who also seen the plaintiff. Then we now last 3 lines of the page.
Yes.
When the plaintiff had admitted that she executed their deeds and it was signed by her, but during evidence, she put her LTI to show that she is illiterate. That is the explanation given. Then, my lord, page 34, running page 30, running page 34, inner page 30, paragraph starts with regarding possession.
Yes.
Regarding possession, no doubt on the basis of exhibit D, a plaintiff is in possession because by life estate he was given possession. But it is a life estate, but could also consider the fact that it can safely be said that the plaintiff's possession cannot be disturbed. That is about a particular portion. So long C is arrived. But in respect to suit property, defendants have that their right and interest and person in it. So through plaintiff, and on the death of plaintiff, invariably defense shall get possession. No other person has any possession except in plaintiff on the basis of exhibit D. That is the expression of exhibit D.
So why exhibit D were executed by the minors? Whether that deed has any validity? This question was raised.
Remember, I'm a lawyer with ropes cannot say it to be correct one. But the question is the circumstances otherwise, because the minor has no legal entity.
There is no legal right to transfer.
Legal entity to because that is why.
Yes. Why such deed was taken to be the correct by the learned appellate court?
That is the question of property value and it touches the question of property value.
Yes.
Because the minor's statement is of little significance in the court of law. But the fact is that some statement has come and he has cross-examined on the point. So one thing is that the plaintiff is entitled to certain protection if she is not properly qualified or capable of understanding. No doubt about it. The law is very clear. Special cloak, special protection is there for the orthodoxine and the illiterate persons. But that is
Orthodoxine and illiterate lady.
Yes.
This is the term of the Supreme Court.
But with all my limitations, with all my limitations in knowledge, this is an absolute thing. Some distinguishing features could be there.
Yes. This is not of the absolute proposition of law. There must have some
if circumstances
clarifications and
shows, if circumstances shows that he or she had the other source of information, whether she had any scope of independent legal advice. Because the undue influence is vitiated if it is found that there is independent legal advice.
No elements of misrepresentation or fault. No elements of misrepresentation or fault has come out in the evidence.
So far as the
Misrepresentation or fault.
I am submitting on instruction because I am a late comer in the matter. Frankly speaking, so far as I have seen, subject to correction by our lordship, that there is no specific evidence on the question of misrepresentation or fraud.
PW1 appeared, PW1, that is the plaintiff, they appear and said the facts how she had been misrepresented by the defendant.
তো ভাই সাক্ষী দিয়ে বলেছে ওটা
And
বিক্রি
during
করেছে।
cross-examination, it was not rebutted.
মামাতো ভাই সাক্ষী
Well,
দিয়ে
the
বলেছে।
question is there, what is there on record, we cannot go beyond that. But the question is that my respectful submission would be kindly appreciate or construe the evidence as a whole.
Yes, yes,
ওর মামাতো ভাই বলেছে বিক্রি করেছে।
Oh, oh.
entire evidence has to be taken up.
মামাতো ভাই।
And as we are thinking about this imposing something upon the lady, at the same time kindly appreciate why, how, to what extent my clients will take the risk of inviting such a problem without taking proper precaution. So if discussions were made and if there is a scope of discussion amongst the family members even, that can take away the question of venom of undue influence. Because moment there is a case of that the person concerned had the occasion to discuss the matter with somebody else, it loosens the venom of the undue influence. Because he had the scope to know the.
That is the reason when the undue influence has been pleaded in a plaint or written statement, the other side has the opportunity to contradict by cogent evidences. There is no such evidence from the defendant to contradict the fact. One line is required from one independent witness, village witness.
প্লেন্টিফের
That is, we say, no, these are the dates.
পরে যে
Correct dates.
জায়গাটা বিক্রি হয়েছে।
Question is that denial is there, but
No, denial of a party to the suit who appeared in the dock, oath versus oath is there. I want an independent witness.
ওর মামাতো ভাইয়ের উইটনেস আছে ওগুলো বিক্রি করেছে, আছে ডিপোজিশন আছে অজিত সিংহ রায়।
Ajit Singh Rai is divorced relation of the party. That this year.
DW, Semi, DW.
Ajit Singh Rai.
3 নম্বর।
Kazi, Medana,
ঠিক আছে। অজিত সিংহ রায় তো?
না, Pradut Singh Rai. Sorry, must stand corrected, Pradut Singh Rai.
আর অজিত সিংহ রায়
Pradut Singh Rai.
হ্যাঁ, অজিত সিংহ রায় উইটনেস হিসেবে সাক্ষী দিয়েছে ওর মামার ছেলে, ওখানে বলেছে ও বিক্রি করেছে। অজিত সিংহ রায় লস ক্লাইম।
DW2. Amato Bhai.
মামার ছেলে অজিত সিংহ রায়।
Amato Bhai, cousin.
তার জন্য ঠিক আছে।
আচ্ছা, এখানে এভিডেন্সের কপি আছে? তারপরে ভাই my lord is right in the sense that some obscurity is there on some but certain points.
Yes.
In that case, it may be sent back. It touches the very important question on both sides.
Position cross-examination হচ্ছে, I have heard from the mouth of Arbitral, I have heard from the mouth of Sorosi that she should not disclose the property about just that.
My lord got it. I may read out one line.
From the mouth of
Yes.
But that, what is there that I have tried to divide my attention to that?
Very
Well, so my humble submission is that it is,
Finding of fact regarding miscible cannot be included in paragraph 8, 11H. Input reader, registration, register documents, register of sell it, use the correct terms of it, and
subject to my client permission.
Yes.
My friend is his client is desirous to assist your lordship with some judgments. With my borrowing my just referring that. Yeah, 1994 Madras, page 247, mainly paragraph 8. The one.
সুপ্রিম কোর্টকে বেশ করে এটা আসছে জাজমেন্টটা এটার উপর বেশ করে এসছে 83
This is based on his judgment of 83.
Paragraph 8.
Yes, mainly paragraph 8. And this is has been taken in for conformity to the judgment of Supreme Court, 1989, volume 3, SCC, page 287. देखना बिच्छू 12-13-17 আজকে দিও বেশি দিও না
Supreme Court register document, register sell it, clear prosecution of sell it, and carries a presumption of validity, burden of proof of the party challenging it.
Yes.
But this is he has taken assistance from the judgments of the Honorable Supreme Court. That is 1989, volume 3, SCC, page 287. Paragraph 11 paragraph should be 12, 13, and 17. In the same tune to something has been borrowed from the Honorable Supreme Court judgment.
What by limitation suitable বলে দিয়েছে প্যারাগ্রাফ 14 এই যে লেখা আছে 14
No, what is the paragraph?
11, 12, 13. Next page, the right hand column. Paragraphs are removed.
What is the proposition here?
Regarding this question of validity of the document, how far the execution can be challenged and to what extent? What will be the guideline for the courts?
This is of section 100 of the CPC.
Yes. Regarding shifting of bonus. Of course, there is difference between shifting of bonus and the burden of bonus, burden to prove. Because after the evidence is given, it loses its significance. It is the
এটা দেখ
it is the
এবারে আমি সুপ্রিম কোর্ট রেজিস্ট্রেশন স্যালারি ভ্যালিডিটি
it is Ramati Roju.
প্যারাগ্রাফ
Yes.
And lastly, my lord, 2019 Supreme Court, page 72, paragraph 10, 14, 10, then 14, then 26, 24, and 34.
Extraordinary of position, Calcutta High Court আছে, extraordinary of position, Calcutta High Court judgment দিবেন।
এই পয়েন্টে সাকসিস করলে ওটা করবে,
হ্যাঁ?
এইটা সাকসিড করলে ওটা সাকসিড করবে, কি বলতে চাইবো?
Calcutta. Position.
Yes.
এটা লাগবে লাগবে। And lastly, my lord, so this is the thing, because I haven't argued other points, because those points were not taken in the court below. The legal points were there. And the question of my lord knows that in case of, if a party to the instrument challenges a document, he is to pray for cancellation or setting aside, and he is to pay ad valorem court fees. Upon in a moment he pays the ad valorem court fees, as per Bengal Assam Civil Codes Act section 18 or 21, the court may lose peculiar jurisdiction. That point I am not arguing, because that point has not been taken.
That point never raised. That is not the point here. To be decided in the second appeal.
And my lord, I conclude with this submission that the court, as per section 3 and 5 of the Limitation Act, court, even if the parties do not raise the question of limitation, court suo motu can raise the issue of limitation.
Limitation.
Yes.
What is the limitation question?
But 12 years, after the deed, it is done after 12 years.
97.
No.
97,
In the second appeal, you have never raised this question. This question was decided by the first appellate.
That's why, my lord, I am not,
First appellate court has decided the point of limitation already.
my limitation act সঙ্গে আছে। The, see, well, I am subject to correction of my lordship.
Article 58, 59, 3 years.
No, 5 আর 3 আর 5।
Posting of law.
বলছি,
3 এই তো।
lordship may kindly consider section 3 and section 5
Yes.
of the Limitation Act. Even if the parties do not raise the issue, court can.
Appellate court, এই trial court বলেছে,
First issue was there, whether the suit is barred by limitation or not. It was decided. First issue before the learned trial, whether the suit is barred by limitation or not.
The court has proceeded under the impression that he has done the date of knowledge. Right, for the inquiry, the BLR office, and then he got the knowledge and then he filed the suit. That is the explanation.
Issue number 3 is there, is the suit barred by limitation.
Yes, yes.
It was decided.
Yes,
It was never raised in the appellate court, first appellate court. How you again raise these questions?
My lord, we kindly appreciate with minus of all prudence, experience.
Phase 3 তে এখানে
That
বলা-
is,
Yes.
but the question of law can be taken in the civil and second level. Purely a question of law. Even it is purely question of law. Whether sufficient explanation is there for 12 years.
No,
They
In
said
your
the same premises.
in your judgments, as you have cited 1989 3 Supreme Court cases, 287, it says the second appeal, the Honorable Supreme Court has discussed the view of and the provisions of section 100 of the CPC, and is of opinion that High Court had the jurisdiction only to interfere in the second appeal, the suspension of question of law. Nothing more, nothing less.
Of course. I can.
There may be some, the question is, there may be some other substantial question of law which was not placed. There may be, but that not required to be dealt with in the second appeal.
Well, there are.
That's why in the initial stage, I am asking again and again, both of you, only to illustrate the point which was raised at the time of admission.
With all respect, my lord, I am submitting with all respect.
This is your judgment also.
No, it is not delivered by my lords. So my lord, I am bound, otherwise in that sense bound by that.
Yeah.
I cannot go beyond that. Anyway, my lord, with all highest respect, I am submitting.
Yes.
Laws are always good, but it is not applicable in all facts. That's the difficulty.
Always. That's
So,
why
my
law is changing
my
day by
lord,
day.
kindly excuse my impertinence. Right now, I am not fortified with those judgments in my hand. There are judgments to that effect. Our honorable court also. That the court at the second appellate court at the time of hearing can hear other additional points. No absolute bar. But not excluding the original formulation of point. That should be there. But in addition to that, other points may be taken. And limitation is purely a question of law. And no explanation is there. So my submission is that kindly consider that this being a purely a question of, because limitation that do not take away the right of the party, it take away the relief of the party.
Yes.
Limitation bars the relief, not the right. My lord, permit me to only one portion, third page of the judgment of April 28. Paper book, title 84, 87, 22nd April judgment. Running page 3.
Running page 3 of what?
Of the judgment of the trial court.
Judgment of trial court. Yes.
Paper book.
Yes.
The paragraph starts with, it is further, second paragraph. It is further plaintiff says that when the plaintiff filed was developed, he went to settlement office in the month of June 1985 for inquiry her name in the ROR and had corner of the inquiry or bill about he was full name in 4D. Is never given 1 and 2, son are given 1 and some are given 2.
85 97.
It is the statement of the made in the plaint.
Yes.
So my lord kindly take note of these things. Whatever may be the conclusion
In the
of
year 1985,
Yes.
she went to the settlement office after her health was developed, and for the purpose of recording the name in the settlement record.
Then she came to know, I mean to say knowledge came on that date.
No. This is not the plain case. Plain case is that in the year 1985, when her health was developed, he went to the settlement office for recording. Thereafter, for the purpose of recording, on 22nd of April 1985, he made a Arpanama. This is the case of plaintiff.
So Arpanama and the immune deeds are correlative. Not detachable.
Yes.
It's a compact thing. And I have invited this portion because to show the date of knowledge when it started. When she thought it necessary or came to know something about the scent of the court. Supposing she couldn't understand what happened on the date of registration.
Yes.
So at least on that date she had knowledge, and from that date counting of 12 years and section 3 and 5 of the Limitation Act. Why not can make an inquiry? কি বলে শেষের দিকে হবে So they
Yes,
do
any further?
that. No, that's all, my lord.
Yes, thank
Grateful,
you,
lordship.
thank you. Reply.
Regarding the limitation point, your lordship will find, though my lord, it is not my lord pertinent here because 101 of the civil procedure section 101 is clear. It's written that no second appeal shall lie except on the ground mentioned in section 100. So your lordship's smaller scope within the parameters of the substantial question of law, not beyond that. Although my learned senior counsel has taken this point, in the plaint it is already written, my lord, in 9. Your lordship will find page 6 of the plaint.
Yes.
In 11, my lord, from the top.
Yes.
1995 সালের জুন মাসের প্রথমে স্থানীয় সেটেলমেন্ট অফিসে স্বয়ং উপস্থিত হইলে নিম্নত ক তফসরে বর্ণিত সম্পত্তি বাদিনী নামে হাল পর্চায় লিপি না হয় বিষয় ও তাহা 1 নম্বর 2 বিবাদীগণ ও তাহাদের নাবালক পুত্র যথাক্রমে 3 নম্বর 4 নম্বর বিবাদী নামে নামিত ভিন্ন ভিন্ন খাতিয়ানে লিপিবদ্ধ হয়
Yes, I have got the
জাগত
fact.
হয়।
Now
Yes.
only reply on the law point only, no fact.
No, that is the regarding I am countering his submission legal point. Your lordship knows that the point will recount. Even the recent Supreme Court judgments also says point will recount from the date of the knowledge.
Yes, proceed. Any on legal point
Now,
reply?
regarding the legal point, I have already argued that in the every deed, your lordship, if he is literate lady, that clause should not be there. In your lordship will find in the every deed, it is written that Kovala Datrike Shunailam o Bujailam. In every deed, your lordship will find. So if she is plaintiff is a literate lady, this clause should not be there.
Yes.
That Lekhak Bonkim Chandra Chaudhary was not presented before the court below. Second point, my lord, he urged one point, my lord, that is registering office. The kindly sees the evidence of the my lord, some officer of the registering office. He has, my lord, only said about the execution of the Orponnama. Regarding the 4 deeds, my lord, that officer remains silent. There is no evidence. And third one, he said, my lord, that the one of the deposition made by my lord, my mom, what is Mamato Bhai, like his deposition, kindly, my lord, have a look into whether your lordship will rely on this one.
No, I shall not go to the facts. I have already read out the deposition.
Yes, and the thing is that, my lord, execution, that is, my lord, rebuttable one. So section 31 of the specific relief is there. Section 31, my lord, gives me power to, my lord, file a suit, even if it is registered. Validly registered, even if.
Yes.
So, my lord, there is a, my lord, presumption go in favor of the plaintiff. Why plaintiff, my lord, after he says, and every day says that I want to sell off the entire property for the purpose of that I want to go to the theatre. So when after 4 days she will again, my lord, take the 4 decimal of land, my lord, by Orponnam, 2 decimal of land, my lord, by Orponnam. And regarding, my lord, his position, they have, my lord, failed to produce any document. The learned appellate court below says that so kindly see that part. I am reading now only that part.
Saying some facts also.
No, I am saying only the lacuna part which you have failed to produce. And you.
My lord is here.
Yes.
The conscious money has not been returned. Supposing it is useless or false.
No, my evidence is it is not paid.
Returned.
It is not paid. My evidence is that.
The immediate document carries greater probability.
Now, issue number 8, how, you know. Okay. No, actually.
What you want to demonstrate? Tell me.
No, I'm just countering his submission.
What point?
Point, he said that he is in position. That is not relevant here for the purpose of. So, at another point, your last occasion, your lordship rightly pointed out, as such, if your lordship go through their written statement, it cannot be considered as a counterclaim. Without any declaration, that's why the two questions are interlinked in the substantial question of law. Whether the appellate court, first appellate court was rightly declaring the title in favor of the plaintiff when there is no such prayer.
Substantial question of law.
Can you if your lordship read the substantial question law formatted by this honorable court, two questions are there, and both are interlinked.
Whether it was a wrong legal test or whether it was wrong in favoring title, declaring
Yes.
title in favor of the defendant.
Defendant without no such prayer is made. Even it is not even the counterclaim. If your lordship go through the order 8 root 6b, counter has to be stated in the written statement.
Yes.
I'll kindly go through their written statement. There is no such averment is made. To qualify, my lord, order 8 rule 6b. That is, my lord, first appellate court erred in law in declaring the title in favor of the defendant.
Yes, anything?
And last one, my lord. No, position is not reduced. And the learned appellate court below has come to the conclusion that they are in possession without any evidence.
Okay.
Okay, and this is the unimpeachable evidence of the plaintiff, which remains uncontroverted, even the cross. And another point is he raised, my lord, regarding the Land Reforms Act declaration. I think, my lord, your lordship has rightly pointed out, my lord, civil court has no jurisdiction.
Very পড়ে আমি যে বইগুলো রেখেছো সরো সরো আরো সরো বলছেন হ্যাঁ চোখ ঠিক আছে ইয়েস that's all okay thank you
And the judgments they are cited, my lord, this, my lord, first one is, my lord, I've seen that first one is a, my lord, parameters of the second appeal, my lord, it is 89.
89 Supreme Court
Yes, parameters of the second appeal, even no party can go beyond of it. And the second is, my lord, is that the presumption of a registered document. That is rebuttable, my lord. That
2019 Supreme
yes,
Court.
that judgment also discussed whether plaintiff has a right under section 31. That is a statutory provision, my lord.
Yes
That's all. My lord.
okay thank you please take down argument not be able to parties concluded with CB. Here we go.
Wait.
সকালে পাওয়া যাচ্ছিল না না হিয়ারিং অ্যাপিল গুলো খুঁজে না পাওয়া গেল মুশকিল একটাও ক্যান নেই okay thank you
Wait.
call the list not today next
May I please lodge, this is my application under order 22 rule 10. My lord, the applicant seek your honors to intervene in this matter for the reason that the suit property, which belonged initially to the Panchanon Arakushi, he filed a suit. He transferred the property in favor of one
your can 7
yes, your honor. Panchanon Arakushi transferred the suit property in favor of one Rohini Kumar. Now, Rohini Kumar transferred the suit property in favor of one Bharat Mondal. Now, the said suit property ultimately in a suit for partition, in a partition deed obtained by his brother Kalidas Mondal. Now, Kalidas Mondal expired. His heirs had transferred the suit property in favor of the applicant. The suit property being 92 decimals of land in 3 plot numbers that we have stated. Now, we, after obtaining the suit property, we are in possession. We are cultivating the said land. Now, all on a sudden, the heirs of Panchanon Arakushi, they tried to interfere with our possession. We filed a suit. And the said suit,
you are the means applicant filed the suit
applicant as plaintiff had filed the suit. Now, the heirs of Panchanon Arakushi, they being the party out there, they came before the learned court below and they stated about the present pending proceeding. That initially, what has been alleged and the suit, that is the appeal that is pending before lordship, that Panchanon Arakushi was the owner of certain plot of land, being the suit property. He transferred the suit property in favor of Rohini Kumar. That is in the year 1955. Now, Rohini Kumar transferred the said property in favor of Kalidas brothers, one of the brother. And thereafter, they amongst themselves, after partition, the suit property was transferred, but that was not the subject matter of that suit. Now, it was alleged by Panchanu Narakushi that after the suit property was transferred by way of a deed of mortgage. Now, as he tried to get back the suit property after after discharging the mortgage, but it was not done. So he filed a suit for releasing of his properties. The suit was declared.
So it was filed by whom?
Panchanu Narakushi.
Panchanu filed the suit.
Yes.
That the
Heirs of the appellants, the predecessor in interest of the appellant. Now the suit was decreed ex parte. Now, Kalidas Mondul, who subsequently purchased the property from Rohini, he challenged the said appeal after getting himself substituted in the proceeding. Now the said decree was set aside, ex parte decree. The appeal was allowed. Subsequently, the years of Panchanu. This is the second appeal. Now, second appeal by the years of Panchanu Narakushi. Now, the present proceeding are not being contested by the years of by vendors, being the years of Kalidas Mondul. All along, your honor would be it would be evident from the orders itself and from the record that no one on behalf of Kalidas Mondul, who are my vendors, they are not participating out here. And we came to learn about this from the injunction application. What has been written statement filed by the years of Arakushi, that there is a pending proceeding out here. After great search and hardship, we could come out about this appeal.
So, what is the matter of Can 7? Have you served?
Served, yes, Sir. Last time we filed the affidavit on service. Last time also, no one came on behalf of the appellant. My lord, your lordship opined to produce all the deeds, relevant deeds.
Okay.
Yes, Lordship. My lord, these 4 deeds are there. Can you have a look into it? First is a copy of the certified copy of the deed executed by Panchanu Narakushi in favor of Rohini Kumar. It's the writing is it's not legible, so I had a typed copy of the deed. But it would be evident that Panchanu Narakushi has transferred the suit property in favor of Rohini. And the second deed, your lordship, of 6884 of 1995, whereby Rohini Kumar had transferred the suit property in favor of Bharat Mondul. That is, soon after purchasing the property, Rohini had transferred the entire suit property in favor of Bharat Mondul. And the third deed, your lordship, is a partition deed. It's all amongst the brothers of Bharat Mondul, the person who had purchased the property from Rohini. And it would be evident, your lordship, from the last page of the deed, the last page of the said partition deed.
Yes.
My lord, চতুর্থ পক্ষের অংশের চিহ্নিত জমি 1, 2, 3. One is হালদাগ 860, 1909 and 859. These are the suit plots. 1909, 859, 860. These are the suit properties. And thereafter, after obtaining the means after partition, by last deed, your lordship, it was transferred. The years that Kalidas expired, his years had transferred the same in my favor. And in the said deed, it was alleged by my vendor that the suit property was without any encumbrances. So I was, and after the transfer, I was owning and possessing the said land.
Okay.
Yes, lordship. So we had come before this with this application, your lordship. I should be allowed as a party, and I should be allowed to proceed with this proceeding.
Can 7 of 2024 decision application under Order 20 Rule 10, Order 22, Rule 10 within bracket 1 of the Code of Civil Procedure. Full stop. The applicant submits that they had purchased the suit property from the erstwhile owner who are the heirs of deceased Kalidas Mondol. Full stop. He submits that as their property, after such purchase, they are possessing the suit property. After purchase, the applicants are possessing the suit property. Full stop. As their possession was disturbed by the heirs of Subal Arakusi, Panchanan Arakusi, heirs of Panchanan Arakusi, they filed a suit before the competent civil judge junior division in the year 2020. In the said suit, the defendants also filed the written statement. Now, the defendant contested the suit by filing a written statement wherein they have stated the pendency of the instant second appeal. After long search, they came to know that on previous suit, which was resulted to the instant second appeal, is pending. It is the case of the applicant that they are the owners of the suit property in question. So they are entitled to added as a party respondent in the instant second appeal. Full stop. The copy of application being 7 of 2024 Paradelico was served upon all the parties. None appears on behalf of the applicant or respondent. Full stop. Considering the fact that the applicants has demonstrated a good case, demonstrated their right over the disputed property. So they are entitled to add as a party respondent in the instant second appeal. Accordingly, Can 7 of 2024 is considered and allowed. Full stop. The present respondents, no, the present applicant be added as a respondent number. What will be the number of respondent? How many?
Seven, eight. 8 of them are there.
How many applicants are there? You are
Applicants, Your Lordship, 6.
6. 9 to
No, applicants, Your Lordship, applicant only 1.
1 applicant.
Yes, Your Lordship. Applicant is 1. And applicants is 6 in numbers.
Okay. There are 8 respondents. So you would be respondent number 9. Added as a respondent number 9. Full stop. In the next paragraph, the office is directed to make necessary entry in the cause title of the memo of the appeal within a fortnight. So no one is appearing in this matter. So what can be
No
done?
appellants are appearing.
Only appellants are appearing.
No.
No one is appearing.
Yes. Because respondents, Your Lordship, they have no interest out there. They don't have any interest because they have sold it to me.
Okay, I am fixing a date for further hearing.
Yes.
If they are not appearing, then the matter should be disposed of.
Yes, yes.
Let the matter appear in the list on 21st of February under the heading to be mentioned. Next. Can 7
Obliged,
dispose?
Lordship. Obliged.
Next. Yes, 7 and 8. Not today.
Nine minutes. And for the appellant and my learned friend is the respondents. It is a joint application for compromise. It is a long pending appeal. So at the intervention of the well-wisher of the locality, in terms of the application, the application is disposed of. I have stated. Paragraph 4 at page 7 in my application can 6
And 6.
Yes. At page 7 paragraph 4 the bottom. This appeal is pending in the Honorable Court for about 3 decades. At the intervention of the well-wishers, the locality, both parties mutually agreed to withdraw the appeal on the following terms and conditions. At page 8, small a, the appellants will transfer the plot number as 0.09 decimals of with their number substances by registered sale deed in favor of the respondent opposite party within 2 months from the date of disposal of the taken appeal, and on that date, the respondent opposite party will transfer their stall land, plot number 136 measuring 0.5 decimals and 0.5 decimals of plot number 138 with their number substances moved by registered deed in favor of the present applicant. Both the parties agreed to hand over and take over their respective possession of the lands as soon as the respective sale deeds registered by and between the parties. Both the parties agreed to act in terms of the condition as stated above and agreed to obey the same. Terms and conditions of the compromise are outcome of free volition of your applicants, and there is no coercion or undue influence in arriving at such compromise. That none of your applicants are taking advantage of their own ground. The parties to the proceeding are voluntarily agreed not in collision to each other, and the appropriate terms and conditions are legal and valid, and no question to be raised by any party after disposal of said compromise. Is and terms and compromise considered of the terms. Alright, this is our joint prayer. Let the application, the appeal be disposed of in terms of the paragraph 4 at page 7 of our application.
All the parties here?
Yes.
Anyone left?
Those who are left, their legal representatives are substituted and they are in this joint petition. And application, Vokalatnama also there, both parties.
What is the suit about?
A suit for declaration, and injunction. It is a
The second appeal can be disposed of in terms of the compromise adopted or
yes,
entered into between the parties.
yes.
But the legal aspect has to be kept open. Okay, legality and validity I have not gone into.
All right.
Okay.
All right, yes. Since both are agreed, the transfer between the parties.
Please take
By-
down
by
6
register.
of 2024.
Yes.
Decision joint application of compromise filed between the parties in the second appeal. Learned counsel appearing on behalf of the appellant submits that after long battle between the parties, after long legal battle between the parties, the friends and well-wishers intervened and there was a compromise between the parties outside the court. Full stop. In terms of the compromise, they have intended to settle the dispute between themselves by executing certain deeds. Full stop. They have entered their compromise in the terms of their compromise in paragraph 4. 4 A, B and C. In paragraph 4A, 4B and 4C of the application being 6 of 2024. Full stop. Next paragraph. Learned counsel for the parties also submits that all the parties to the second appeal has entered into the compromise. They have signed in the application for compromise being Can 6 of 2024. Thus, they seek necessary order. Full stop. For the learned counsel for the parties, it also appears that all the parties to the appeal, second appeal, had signed in the compromise application being Can 6 of 2024. Full stop. I have also perused the terms of compromise. It appears that the parties intends to transfer some portion of properties between themselves to settle the dispute, which was raised in the instant second appeal. Full stop. Next paragraph. The validity and legality of the transfer between the parties are only binding upon the parties itself. The same cannot be considered at this stage. The same be kept open at the relevant point, open to be raised at the relevant point of time. Full stop. However, as the parties are entered into a compromise, so it is impediment. It is impediment to dispose of the instant second appeal in the terms of the compromise. Under the above observation, Can 6 of 2024 is disposed of. Can 6 of 2024 is considered and allowed. Full stop. Let the second appeal be and the same. Be disposed of in terms of the compromise entered between the parties to the appeal at paragraph 4A, 4B, and 4C of CAN application being CAN 6 of 2024. Full stop. Decree be, next paragraph, decree be framed accordingly. Decree has been framed.
Urgent,
Appeal disposed of.
LCR you can be sent down.
LCR if received, LCR, TCR. If received, be sent down to the report the learned court below. Immediate.
Urgent Xerox certificate.
Next.
Urgent Xerox certificate. Undue.
Next.
Lawsuit. Lawsuit, item number 10, I am appearing on behalf of the appellant. And 11, I am the respondent. Both the appeal arising the same judgment and decree. My application, I already served the copy of application upon the learned advocate appearing on behalf of the respondent and second matter appellant. First can is the application for restoration.
CAN 2.
CAN number 12715 of 2019.
Nineteen 19.
2019.
2019.
Yes, Lordship.
When you filed the application? 24th of December 2019.
Lordship, 17 days delay. That was also explained, Lordship. Para 7. And para 4, 5, 6, 7. 4 paragraph, I explain why I am not appearing.
So you are appellant of 478.
478.
Second appeal 478, 93.
93.
And respondent in
310.
94.
94.
Is there any application for
No,
restoration of that appeal?
no, 310, no application for restoration was
Then?
filed. My application may be considered lawsuit. Otherwise, I cannot
What
file
are the applications CAN 1 and 2?
CAN 2 is the application under Order 22, Rule 10. Read with Order 1, Rule 10.2. During pendency of the appeal, appellant number 2 transferred the suit property as well as other property to the legal heirs.
That is CAN 1.
CAN 2, Lordship.
CAN 2.
CAN 1 is the restoration application by 12715 of 2019. That is the old number. New number is CAN 1. And CAN 2 is my application under Order 22, Rule 10.
What is this CAN? CAN 1 of 2025?
That
In
is
respect of second appeal 310. Have you filed it?
Lordship.
Whether you have filed the application? ওটার কথা কে বলছে? ওটা দেখেছি এইটা আর এটা 310
That was 310 lawsuit. Both appeal, same application was filed.
you have filed the same application
Lawsuit,
310 you have also filed the same
lawsuit,
application
lawsuit,
that why I'm asking
lawsuit.
you have filed this can one in 310 also
Also,
that's
lawsuit,
why I'm asking you what
lawsuit.
so what would be the purpose for restoration of only single appeal
Lawsuit, actually, if restore this matter, then automatically both appeal was restored. Because of the two appeal was tried analogously, order was passed. And
order was passed there
lawsuit, earlier order was passed, to appeal was lawsuit, on 10/6/1996.
what is the show me the order
10/6/1996. If you lawsuit kindly permitted to another
order.
copy, I can find out this order. Lawsuit that recording related to 310. That order was passed, is number 478 of 1993.
478
478.
478 কোথায় এটা 478 দিন
Lawsuit.
have you got it
Yes, lawsuit.
give it to me these are the old records
Yes, sir. So, only last portion lawsuit, if last portion, bottom portion.
okay please take down can 1 of 2019 within bracket old can 12715 of 2019 this is an application for restoration of the appeal by recalling the order dated 4th of November 2019 passed by this court. Full stop. Learned counsel for the appellant submits that both the appeals are being heard analogously. Full stop. The learned advocate for the appellant was engaged in other matters, so he could not appear before this court on the day of hearing. We prayed for necessary order for restoration of the appeals. Having heard the learned counsel for the parties, also considering the order passed by this court on 10th of June 1996 regarding the order of analogous hearing of both the matters, it appears to me that both the appeals are dismissed for default by the order of this court dated 4th of November 2019. I have perused the grounds mentioned in Can 1 of 2019, bracket old Can 12715 of 2019, bracket close. The grounds appears to me justified and sufficient. Hence, Can 1 of 2019 is considered and allowed. Order of dismissal passed by this court on 4th of November 2019 is hereby recalled. Full stop. The appeals, the second appeals being number SA 478 of 1993 and SA 310 of 1994 are hereby restored to their original file and number. Full stop. Appellant is directed to inform the serve notice upon the learned counsel for the respondent regarding the restoration of the appeal. Let the matter be appeared in the list under the heading of application on 21st of February.
Also, affidavit service kept in the record.
Affidavit of service filed on behalf of the petition appellant kept in the record. Be kept in the record.
Item number 12 is, I'm for the appellant, my lord.
It is director.
My lord,
Next matter. Yes.
I'm appealing for the petitioner.
So who is for the
But this is my application for restoration. A restoration of an order, recalling of the order, dismissing my appeal in the year 2019, 5th of March 2019. Therefore, application for restoration was filed by the erstwhile advocate on record. Subsequently, there is a change of brief, a change of advocate on record. But after coming, my lord, I have filed an application for section 5, explaining the delay in filing the application for restoration.
how many days delay?
My lord, almost 2 years, my lord. Because application, the dismissal was of 2019. Application for restoration was filed in the year 2021. May I serve the copy of the application, both the restoration and the section 5?
Yes, you serve.
And come back after a fortnight before your lordship?
Yes.
Let there be that.
Item number 12. Appellant is directed to serve the applications upon the respondent. Both the applications, both the applications of the respondent. Full stop. Let the matter appear in the list on 14th of December, 14th of February. Okay.
Item number 5. Adopted the interim order has February, date fixed for the trial court. The second appeal has been admitted, question of law has been made, and there was a stay of the order, and the stay was certified. In one of the 5 days, the matter can.
You mention it. Okay.
So, this is original.
That appear for the petitioner. This is that matter where not the weight of the cylinder was found to be not conforming to the requirement of the petroleum company.
Yes.
Oil company rather.
Mr. Mojumdar, have you concluded your
But
summary?
only two, but just to sum up so that my learned friend can reply today.
Yes.
But 4 points I have highlighted.
Yes.
Now, these are all available on record, and all are admitted facts. But the allegation was out of 20 cylinders weight, some were found to be underweight. Therefore, the percentage of cylinders which were found to be not conforming to the weight of the oil company was more than the permissible limit. To this, the reply is 26 cylinders were weighed, not 20. 26 cylinders were being taken away, were uploaded in the vehicles.
26.
26 vehicles. So if 4 cylinders are found to be underweight out of 20, the percentage would be something. If 4 are found to be underweight amongst 26, then the percentage will be less.
Yes.
So that's the first perversity in their action. But for that, I had referred to page 117 of the repetition. 117 of the repetition.
Yes. Page 117.
My lord. In the second volume, please come to page 117.
Yes.
The paragraph beginning with the words the entirety of the cylinders. First, second, third, fourth, fifth line from the top of that page.
Yes.
The entirety of the cylinders cited in the QRC report, that's their own report, encompassing a total of 26 cylinders are part of the random weight verification of filled cylinders at the godown. The authorities proceeded on the basis of 20 cylinders. Not our stand was there were 26 cylinders, out of which 4 were allegedly found to be underweight.
So this is the appeal.
This is my appeal.
This is your appeal.
But I referred total of 26 cylinders as mentioned in the QRC. That's their own report, in their own report. As cited, the entirety of the cylinders cited in the QRC report encompassing a total of 26 cylinders. So that's the first perversity.
Yes.
Second is, that there is no allegation of tampering of the cylinders. So if the cylinders are underweight, that's a manufacturing default. But please not for the time being carry your lordship's mind as a normal human being, not who is not a purchaser of a cylinder or a customer of a cylinder.
Yes.
The cylinders are not tampered with, seals are not broken, but underweight cylinders are in the godown. Who has manufactured these cylinders? So it's ultimately the distributor which is being penalized for the manufacturer's default.
Yes.
The manufacturer has committed a fault, the distributor has not pointed this out. Therefore, the distributor should be penalized. Please visualize the reasonableness in a state action. But this order has to be tested not in the anvil of reasonableness in state action. And what this calls for not public interest to be weighed. And it does not remain in the contractual field anymore. But third point.
Yes.
Which is very fundamental in nature. Not the marketing discipline guidelines are framed to control or not as a guideline for all oil companies. Vis-a-vis their distributors. The oil companies will also have to follow them. The distributors will also have to follow them. So not when we go to a petrol pump to buy petrol, not we all know that these are the guidelines which are to be followed. The distributor knows, the petrol pump owner knows that he has to follow these guidelines. And I know as a customer that these are the guidelines which I can avail myself of.
Yes.
Now, these guidelines have reference to the Legal Metrology Act, and there is a permissible limit of 150 grams deviation. And this 150 grams can only be weighed if the figure is counted up to 3 digits after the decimal. So the authorities themselves have deviated from their own guidelines, or not the marketing guidelines, which your lordship will be pleased to find from page 49 of the writ petition. Please see 1.4 clause C at page 49.
Yes.
All the cylinders taken out for delivery should be checked for correctness of net weight on the platform type digital weighing scale of least count plus minus 10 grams prescribed in the legal metrology packaged commodities rules 2011 as amended from time to time. Cylinders that have net weight beyond permissible limit prescribed in the legal metrology rules as amended from time to time should be segregated and returned to concerned bottling plant. So now two things come out clear. Not one is adherence to legal metrology rules as amended from time to time for the purpose of this relaxation in weight, and this difference in weight is attributable to manufacturer, because the distributor has to weigh, and if some underweight cylinder is found, it has to be returned to the manufacturer. Now please come to the legal metrology rules. Note, I had cited this on the last occasion. Rule 22 first. General list. Schedule 1, no? Schedule 1. First schedule, table 1. But the rules have various tables. Please come to schedule 1. First schedule is denomination, materials, shape, and permissible errors in respect of reference standards. Your Lordship has got that? দুটো দিন একটু বার করে দিয়েছি।
First schedule,
First schedule,
yes.
part 1 has reference standard weights. Then please come to
Denomination of material shape and
this
permissible
maximum
errors.
permissible errors.
Maximum permissible errors, denomination and permissible errors.
Yes. Your Lordship will be pleased to find there is a reference to 3 digits after a decimal from 500 from
20 kg.
yes,
After since 20 kgs, there are 3 decimals.
3 decimals. Now, there are platform scales in the godown.
Yes.
The authorities say that since the cylinders were already lifted on the carts or those delivery vans, therefore we proceeded on the basis that these were en route vans, since those would be leaving the godown shortly thereafter. Now, please come to the affidavit in reply. I have enclosed a picture, a photograph at page 32. '31 also. Now, this is how a handheld weight is taken.
Yes.
Please see, after decimal there are 3 digits. So, non-compliance of the laid down guidelines apropos the law framed under the legal metrology rules has resulted in a perverse finding. The order proceeds on 1 digit only. 1 digit after the decimal. At page 80 of the writ petition.
Yes.
Please come to 78 first, and then I shall take your Lordship to page 80. Not on the left hand column, your Lordship will be pleased to find a heading equipment.
Yes.
Then total.
Total.
Then random SQC of cylinders.
Yes.
Then please see seal OK against respective serial numbers. All seals were okay. Now please come to page 80. When the law prescribes a deviation or error up to a permissible limit, could the authorities violate this law by making reference to only 1 digit after the decimal? Variation in kg minus 0.1. That's 10 grams. Please see the entry number II after the column. Electronic weighing scale available with least count plus minus 10 grams. So, not the electronic scale was available. Very well, they did not measure it through the electronic scale. They measured it through the handheld scale. But even then, the handheld scale ought to have been considered in the light of not the availability.
3 digit after the
3 digit. Not an addition of one digit after a decimal will make the whole world of a difference. Please subtract 0.10 from 0.50 and please subtract 0.1 from 0.5.
Yes.
Now, Lord, comes the question of exercise of jurisdiction by the writ court. To what extent will the writ court go into these issues?
Yes.
But I am not my client is not inviting your lordship to find out through examination or through the scrutiny of facts as to whether this was 0.2 or 0.5. I say you applied a wrong process in the decision making exercise. And that's exactly the jurisdiction of the writ court. To find out what is the error in the decision making process.
Yes.
The error in the decision making process very evidently is twofold. One, non-compliance of page 49, that's the MDG guidelines. And number two, not complying with the table under the law.
Yes.
If the respondent, not as students of law, not we have tried to learn that respondents are bound by the standard they lay down. It's a clear case of deviation from the laid down standards of the respondent authorities, and therefore no amount of alternative remedy or not other forum can prevent the jurisdiction of this honorable court to be exercised. And my learned friend had cited 2023 2 SCC 703. Please come to paragraph 82.7 of the judgment.
Paragraph 82.3.
7. Lordship, may straight come to 82.7.
Yes.
The existence of an alternative remedy is undoubtedly a matter to be borne in mind in declining relief in a writ petition in a contractual matter. Again, the question as to whether the writ petitioner must be told off the gates would depend upon the nature of the claim and relief sought by the petitioner, the questions which would have to be decided, and most importantly, whether there are disputed questions of fact, resolution of which is necessary as an indispensable prelude to the grant of the relief sought. But does a reference to page 80 apropos the rules lead to a disputed question of fact to be answered as a prelude to the relief sought? Undoubtedly, while there is no prohibition in the writ court even deciding disputed questions of fact, particularly when the dispute surrounds demystifying of documents only, the court may relegate the party to the remedy by way of a civil suit. Suppose there is a paper arrangement or there is a hidden fact which is sought to be given a camouflage through a documentation, and that documentation needs to be gone into through adduction of evidence. What was the intention of the parties to the contract? But in such cases, not the writ court may not exercise jurisdiction. But am I questioning the guidelines or the agreement? I am not.
Yes.
Now, page 82, paragraph 82.9. The need to deal with disputed questions of fact cannot be made a smokescreen to guillotine a genuine claim raised in a writ petition when actually the resolution of a disputed question of fact is unnecessary to grant relief to a writ petition. Writ applicant. The reach of Article 14 enables a writ court to deal with arbitrary state action even after a contract is entered into by the state. A wide variety of circumstances can generate causes of action for invoking Article 14. The court's approach in dealing with the same would be guided by, undoubtedly, the overwhelming need to obviate arbitrary state action in cases where the writ remedy provides an effective and fair means of preventing miscarriage of justice arising from palpably unreasonable action by the state. Now, what is the palpably unreasonable action by the state in my case? Number one, the Article 12 authority has not followed its own guidelines. Yes. Number two, the guidelines refer to law, and the law, not only the law as amended from time to time. This has also not been adhered to. So, violation of law at the behest of an Article 12 authority is a palpable, unreasonable state action. And therefore, my case comes under paragraph 82.9 and 10 of the judgment. Yes. Now, please come to the last sentence of that page 82.12. What must be involved in the case? Now, the sentence starts from the middle portion of the line. What must be involved in the case must be action or inaction which must be palpably unreasonable or absolutely irrational and bereft of any principle. I'm not pausing here for a moment. But what would this lead to? This would lead to penalization of a distributor in violation of law for a fault on the part of manufacturer. What can be a more glaring instance of arbitrariness? Yes. Somebody else has committed a wrong. I am to detect it. Very well. I agree to that guidelines. But the process of detection is laid down in law in terms of the guidelines itself. And you don't adhere to your laid down law for your own mistake. And consequently, I get penalized. There is one more judgment. But this is a very well propounded principle, but still not only to show that even today, what was in the 17th century has been followed today. Please come to paragraph 15 of that report. It is a settled law,
Paragraph
15, that where a power is given to do a certain thing in a certain way, the thing must be done in that way or not at all. Other methods are necessarily forbidden. Reference can be made to so and so. But what is striking is other methods are forbidden. So when with reference to page 49, apropos the applicability of the rules of legal metrology rules of 2011, reference for error detection is permissible up to 3 digits. Other method is forbidden. Yes. And therefore, the order or the state action is a forbidden action. So, in my most respectful submission, this is one of the probably one of the oldest distributors in Kolkata, insofar as IOCL is concerned. But I humbly pray before your lordship that this order of the authorities should not be allowed to sit at rest and the penalty order be revoked. These are my submissions. May I have your lordship?
Yes, for the IFC.
Right, we'll take some time. My learned senior friend has argued for 4 days. It will take some time for me to reply. Well, I will just start today. You should kindly
Yes,
permit
yes.
me to continue on the
You
next.
can start today.
Well, first of all, I will like to interpret the guideline, the marketing discipline guideline, which my learned senior friend submitted, that the authorities have failed to comply with their own guidelines. That is one of the that is the only case. That is the only case, I will say, that is the only case made out by the writ petitioner so far as the action of the authority is concerned, that the authorities have not complied. The decision, there is a flaw in the decision making process. There is no disputed question of fact. There is a flaw in the decision making process. Since there is a flaw in the decision making process, this honorable court should struck down the decision.
Yes.
And the reason behind saying so is the guideline not being followed by the corporation. Now, my kindly consider that guideline, the relevant portion of that guideline. Kindly consider that. May I place it from my affidavit in opposition, ma'am?
Yes.
It starts from page 47. Opposition.
An extra check. 37.
Sorry, it was my. May I place it from the writ petition itself? It's there in the writ petition. Page 47 of the writ petition.
Oh. Marketing discipline guidelines.
Yes.
Yes.
Now, kindly appreciate what is the object, what is the purpose of framing this guideline. May I place the third paragraph at page 47. The LPG distributorships are appointed by public sector oil marketing companies and are governed by terms and conditions of agreement entered into between the OMCs and the distributors. The various clauses of the distributorship agreement spell out the several responsibilities that have to be performed by the distributors as well as the OMCs. Besides the responsibilities spelled out in the distributorship agreement, there are operating policies, procedures, and practice that are required to be followed by the distributors to serve the LPG consumers. The object, because the relation between the oil marketing company and the distributor are governed by a contract.
Yes.
It is the distributorship agreement. But apart from complying with the terms and conditions of the distributorship agreement, there is these guidelines have been framed to instruct both the oil marketing companies and more particularly the distributors, while they are serving the customers, to follow certain procedures and policies. Now kindly please the next page, clause number 1, page 48. First clause. It will be the responsibility of the distributors to sell product of correct quality and quantity and provide excellent customer service. This is the very basic responsibility of the distributor to supply the product. The product should be correct, as well as the quantity also to be correct. That is the primary responsibility of the distributor to comply with. Now, my lord, kindly consider the entire procedure. How, like the LPG cylinders are filled up with LPG at the bottling plant of the oil marketing company. From the bottling plant, the cylinders come to the godown of the distributor.
Yes.
Now, when it reaches to the godown of the distributor, distributor has certain responsibility to check whether a correct product with correct quantity has been supplied to it or not. Otherwise, it will be the responsibility of the distributor. If there is a fault, if in the product, then the entire responsibility will be on the distributor, because the distributor will be supplying that particular product to the customer. So there is a specifically procedure laid down in the guideline as to how a distributor, what procedure the distributor has to follow while receiving the LPG cylinders from the concerned oil marketing companies.
Yes.
Now, the first point is the receipt of the product. At the time of arrival of truck carrying filled cylinders, the distributor should match the details of the invoice with the receipt of consignment in the following manner: the truck number, type of cylinders, number of cylinders, the time when the truck left supply point, the time when truck reported at godown. Next, uploading of filled cylinders at the storage godown. The distributor to carry out the following: separate area should be marked in the LPG storage godown for keeping filled, empty and defective cylinders for each type of cylinders. So the procedure is, in the godown there should be separate areas marked by the distributor to keep the filled cylinders, to keep the empty cylinders, and to keep the defective cylinders, the faulty cylinders. Because if after a cylinder,
there should be a separate area. Those defective cylinders.
Right. And when this defect, the detection of the defect should be carried out, this has to be done and by the distributor while receiving the product from oil marketing company, because a product can always be defective. Now, if the product is defective, it has to be kept aside and returned to the oil marketing company, saying that this product is defective. And that is the purpose why the guideline says that when a cylinder comes, the distributor should weigh that particular cylinder in a platform-based weighing machine kept at the godown. So, if a particular cylinder is sent for delivery by the distributor, then it will be assumed that the distributor was of the opinion, or distributor was confident about the correctness and the
correct quality and quantity of the cylinder.
Right. And how that could have been detected? Because it is not the responsibility of the oil marketing company to keep their person at the particular godown for each and every distributor's godown while unloading the cylinders. Transporter will unload the cylinder. the distributor, while receiving the cylinders, distributor will weigh each and every cylinder at the platform-based weighing machine kept at the go down. And after he is satisfied with the quantity and quality, he will keep that in a place, identifying that particular cylinder to be correct in quantity and quality. This is the purpose. Now, my lord, kindly see how this has to be done. Separate areas. Now, the platform time, the next point, the platform type digital weighing scale of least count plus minus 10 gram should be checked with standard weigh for accuracy. Now, kindly mark this point. My lord, this has been made. This is one of the procedure marked under 1.2, which is what is 1.2? Unloading the filled cylinders as LPGs would in store out. So this weighment at the instance of the distributor has to be done while he is receiving the particular cylinder at his go down.
These are the points which a distributor should carry out.
Right.
At the time of receiving the cylinder.
Right. Because this is the procedure that has been laid down. And this has been done, these are not there in the agreement, in the contract. These are the guideline frame so that neither the distributor, not the oil marketing company, and not the customer face any kind of problem. There cannot be any dispute if this detailed procedure is being maintained by each and every person concerned. This is at the instant, has to be followed by the distributor as well as the oil marketing companies. Now, what I am emphasizing on is what was the responsibility of the distributor. The writ petitioner is saying the entire responsibility is on the IOCL, because if they have sent the defective product, why should I be penalized? If the product belongs to the oil marketing company, and if the oil marketing company has sent me a defective product, why I should be penalized as a distributor? Because I am not the manufacturer. There is no allegation of tampering. I have not tampered with the product.
Seal was intact.
Seal was intact. So I have not tampered. There was no allegation of tampering. So what I am saying is there can be a defect in the product so far as weighment is concerned or the quality is concerned from the bottling plant itself. That's why the procedure has been given to keep those defective products aside and send back to the oil marketing companies. Now, that is also provided in the guideline itself, that the defects are to be kept aside.
So it's not required to put in the cart.
Right. It should not be put in a place where the cylinders with correct quality and correct quantity are to be placed as per the guideline. It should not be there. It should have been placed at a area where the defective
separate areas should be marked in the LPG storage go down for keeping filled empty defective cylinders.
Right.
For each type of.
So there are three categories, like the filled one with empty correct quantity, empty
and defective.
There should be separate areas. Now, if it is a case of the writ petitioner that the product was defective and he should not be penalized, then he can't take that point now, because it was his responsibility while receiving the product to check the weighment at the platform-based weighing machine. In neither, because I have taken this specific point in my affidavit in opposition, I will show from the reply to the so cause that the petitioner has not taken a point as to whether he has complied with this particular process while receiving the offending cylinders.
Defective cylinders.
Right. The cylinders which we are saying are underweight. Right. So it is not the case of the writ petitioner has not made a single statement anywhere in his writ petition saying that while he received the product, after he weighed this product in his platform-based weighing machine and found it to be perfect. This case has not been made in the writ petition, neither in the reply, not a single statement. However, I have taken this point categorically in my affidavit in position. Because the provisions which are being relied upon from the guideline by the petitioner has to be done by the distributor, not by the wire marketing company. Wire marketing company will not come and weigh the weighing machine on the platform-based weighing machine. Now I will show the other provisions also. Now kindly see, while on the third point, while unloading filled LPG cylinders, weight of 10% cylinders taken randomly should be checked and records should be maintained in the prescribed form by well machine. Cylinders that have net weight beyond permissible weight should be returned and same in the same truck. While weighing the cylinders, if it is found that it is not matching the permissible weight, then it has to be returned. And that
it is the procedure that only 10% cylinder has to be taken weight. Only 10% of total lot.
On the entire lot, on random basis.
Random basis, 10%.
On random basis. And that's why, and after that, because it unloading and then sending the truck again back, that will not be, the time is not so much to weigh each and every, the entire lot. So it will be on random basis. But while receiving it, while categorizing it, whether it is quantity is in
whether it is underweight or not.
Yes, that is the responsibility because he has to keep it in his go down in separate places.
No, we can assess the issue. If there in a truck there is 100 cylinders, so according to the guideline, the
10 of them
distributor has to be weighed 10. He has randomly taken 10 and weighted. It is appears to be found correct, so he can keep it.
He can keep it, but while he will just receive it and not send it back immediately in the same truck.
So he can keep it in the area in the field cylinders.
Yes. Thereafter, he has to weigh each and every cylinder so as
before distribution.
Right. So that he can, if he finds any defective cylinders, then it will be placed at the defective area. Now, kindly see the next portion. Now, the next clause. So far as clause number 1.4 is concerned, what does it say? Quality, quantity, control measures.
No, they are arguing on the point that cylinders, the last point, 0.4, 1.2, cylinders that have not yet beyond permissible limit should be returned to the same track.
1.24.
1.24.
Yes.
Cylinders that have net weight beyond permissible limit should be returned. So permissible limit, they are arguing on that point, permissible limit, that would be 3 digit after decimal. And they have argued that you have taken only 1 digit after decimal.
No, not at my point is absolutely this is what my
sorry, that was 1.4 C. That next page, 1.4 C.
Okay, we are proceeding. Yes.
No,
I just take the note that they have argued on that point, that the weight digit should be 3 digit after decimal. This is permissible limit, not 1 digit after decimal.
That is the digit as per the 3 digit after the decimal has to be displayed in the weighing machine.
Yes.
The weighing machine, it has to be displayed in the weighing machine, and the digit, since the oil company has taken only 1 digit after the decimal, that's why the actual process has not been followed.
Yes, that is their argument.
That is their argument. Now I will come to that point, that argument also, because kindly appreciate what I am now showing is.
Okay, now proceed.
What I am now showing is this is a procedure to be followed while receiving the cylinders at the go down, where the oil company's presence is not required.
Yes.
It is the responsibility of the distributor alone to take the correct product, and after taking the product, it is the responsibility of the distributor to check whether each and every product is correct in quantity and quality or not. If he finds that it's not correct, he has to keep it in a separate place marked for defective cylinder. This is the procedure. Now, kindly appreciate if the cylinders which were during the time of inspection were found to be underweight. These cylinders, the writ petitioner had received from the oil company and kept it and taken it and kept it at a place where the cylinders with correct quantity and quality to be kept. So, according to him, he has followed the procedure. He has never said anywhere this product was defective when it was delivered to him.
When it is received by him.
Right.
First time.
Right. This is not a case make out by the writ petitioner anywhere in the writ petition either or the reply. Now, kindly see the another point which was my learned senior friend was very much emphasizing is 1.4c.
Okay.
Before 1.c, my lord, kindly also see B. %% cylinders should be visually inspected for dents. So who has to do this? Kindly see. This is a procedure to be followed by the distributor. The procedure for handling an LPG. It starts from 1. The 1 says procedure for handling of LPG cylinders by distributors, not by the oil marketing companies. So all these procedure are to be followed by the
distributor.
Now kindly see B. 100% cylinders should be visually inspected for dents and cuts on the body of the cylinders, and damaged cylinders should be segregated and returned to the bottling plant. Similarly, cylinders which are due to statutory testings should also be segregated and returned to the bottling plant. Now kindly see. So any kind of defect, it may not be only weight, quantity, quality. Any kind of defect has to be detected by the distributor while receiving, and any kind of defective product should be sent back to the bottling plant. Now kindly see C. C also is the responsibility of the distributor and not the oil marketing companies. All the cylinders taken out for delivery. Now this is a situation which deals with a situation where a cylinder which according to the distributor is absolutely fine so far as quality and quantity is concerned.
Yes.
And on satisfaction, he is now taking that cylinder to a customer for delivery.
Yes.
Now, while doing that, what is his duty? That is what is mentioned here in C. All the cylinders taken out for delivery should be checked for correctness of net weight on platform time digital weighing scale of at least plus minus 10 grams prescribed in the legal metrology packed commodities rules 2011 as amended from time to time. Cylinders that have net weight beyond permissible limit prescribed in legal metrology packed commodities rule 2011 as amended from time to time should be segregated and returned to concerned bottling plant. So it is not at the first instance also, like while receiving the cylinder at the godown to weigh it on the platform based weighing machine, because that was done on a random basis, because out of the 100, 10 will be picked and choose, and
10% would be taken randomly.
But
at the time of delivery,
before you load that particular product on a load van, it is the duty of the distributor to get it weighed on a platform-based weighing machine kept at the godown of the
Yes.
distributor. Now, it is not the case. There is not a single statement in the writ petition, neither in the affidavit in reply, which by which the petitioner has said the petitioner has
Checked
followed this procedure before loading it
They
on
have
the van.
checked it and loaded it in the
Right,
van
right,
to be correct.
right.
There is no such
No
statement.
such statement, not only in the writ petition, neither in the reply, not even in the, because writ petition reply, I will also show they have tried to make improve their case, because there was a, your lordship knows that in this case there was a detail. There was an inspection, thereafter a show cause notice. Writ petitioner was granted an opportunity to deal with the charges level against him. Accordingly, petitioner has filed a reply to the show cause dealing with all the charges. Thereafter, a personal hearing was also given, and then a decision was taken by the authority. After the decision was taken by the authority, as the marketing discipline guidelines provides for appeal, a provision for appeal, the writ petitioner then went up in appeal before the appellate authority. The appellate authority affirms the decision of the authority. Challenging that decision, the petitioner has filed
Approach this court.
approach. So there were ample opportunities given to the petitioner to place his case before the authorities.
He never demonstrated that before
No.
delivery he have checked the
No.
matter.
No. Petitioner cannot be permitted to improve his case at this stage. If he has the first opportunity, if he has not taken a point at the first opportunity which was granted to him, that is the show cause
Reply to
notice,
the show cause.
right? He cannot take that at a later stage. He should not be permitted to improve his case, because there were two decisions. Kindly appreciate, my lord. There were two decisions, one by the concerned authority and thereafter the appellate authority. There were two decisions. So, considering the two decisions at the third stage, this is the third stage, the writ petitioner should not be permitted to improve any of his case which he has not placed in his show cause reply. So today, even my learned senior friend has relied upon this particularly this clause 1.4c to show that it was the responsibility of the oil marketing company to weigh the weighing machine on a platform weighing machine which confirms the requirement of the legal metrology packed commodity rules 2011. This was the
Plus
only
minus
case.
10 gram.
Yes, this was the only case that was the responsibility of the oil marketing company to carry out this particular compliance. In my humble submission, so far as the express language of this particular guideline says, it is the responsibility of the distributor and not the oil marketing company. The express term says it is the responsibility of the distributors.
You are saying that the distributor never said that they have checked the cylinders and they have checked the deviation of at least count 10 plus minus 10 grams and they have loaded it.
Yes. Now where this detection happened, because I will show from the documents, the inspections were carried out at 3 different places. One is at the store, like the shop room where the customers goes and the customer like dealings happens at the shop room of the distributor. That is at a separate place. Next, an inspection to the shop room happened. The documents of inspection documents I can identify from the inspection documents that each and every inspection reports says at which places this particular inspection happened. The inspection happened at the shop room. inspection happened at the godown, and inspection happened in the en route, in the route. Now, so far as shop room, godown, inspection at the shop room is concerned, there is an inspection report to that effect. There were minor irregularities which were not, which were being waived off. Now, so far as the inspection at the godown is concerned, there are also minor irregularities which were also not been taken care of. But so far as the inspection on the route is concerned, there this underweight cylinders thing happened, this detection happened, and that is the subject matter of dispute. Because the authorities have taken penal action in respect of the inspection which happened en route during the delivery. Now, delivery means what? Delivery will be, en route will be considered as soon as the distributor
Loaded the
loads
cylinders to the
cylinders in the
van.
delivery van. It will be considered that it is en route. Now, I will also show from here that the weighing machine, so far as weighing machines, my learned senior friend has also pointed out that, see, from that particular document, that inspection report, that the weighing machine has to be an electronic weighing machine. In all due respect, my lord, the weighing machines which were used, the platform weighing machine is also electronic, and the hand weighing machine is also electronic. Both are electronic. It's not the case that the hand weighing machine by which the faulty cylinders were weighed were not electronic. That was also electronic. Now, I will also show that if the hand weighing machine by which the cylinders were weighed en route only displayed one digit, as has been recorded in the inspection report, one digit after the decimal, as has been recorded in the inspection report, then it is the responsibility of the distributor, because then the weighing machine was faulty. If it displays,
Your officer says,
no, I will show it from here also. Kindly see, today the inspection happened en route. It's not that each and every delivery will be inspected. This is a random inspection happened. It's not a case that each and every delivery will be inspected by the oil marketing companies. Now, so far as why the hand weighing machine is used, the hand machine weighing is, it belongs to the distributor. The platform based weighing machine as well as the hand weighing machine belongs to the distributor. The delivery van, the delivery man who is going to deliver a cylinder to a particular customer, he has to carry the weighing machine to satisfy the customer as to the weight. It is not that only during the inspection, the inspecting authority of the Indian Oil Corporation provided the weighing machine, hand weighing machine, to carry out the weighment. It's not that case. The weighing machine is with the delivery man, and the weighing machine belongs to the distributor. So if there is a fault in the weighing machine, then it has to be the responsibility of the distributor.
Now, whether it was noted in the report that we have checked the cylinders and the weighing machine showing only
whatever weighing machine showed, that is been reflected in the inspection report. May I place the inspection report which my learned friend has
Now,
read?
who weighted the delivery boy?
Delivery boy in front of the
Inspection team.
Inspection team.
With the machine provided by the distributor.
Right. And the inspection, and whatever has been recorded in the inspection report, that those were being not only countersigned by the delivery man but also by the distributor. I will show that. Kindly see the inspection report. No protest so far as the weighment is concerned by the distributor. at this latter stage, this point cannot be taken on. If the distributor had any objection so far as the payment is concerned, that should have been recorded. She should have recorded that objection because she had recorded some objection in other inspections. But so far as this particular objection is concerned, there is no recording of that objection in the inspection report. Kindly see the inspection report. May I place one of that? 81 of the requisition. Now see, my lord, who had signed this and the date. First of all, kindly see the date at the top, page 81, my lord.
Yes.
14/7/2023. So this is the date of inspection. And these signatures were done on spot because I will show where they have the signatures who have signed the document has also marked the date. Kindly see the at the bottom who has signed. Delivery boy, the left hand side. Distributor's delivery boy, he has signed. At the bottom, minor left hand side at the bottom.
Yes.
Then the right hand side, this is the inspection team with date 14/7/2023. And then bottom, S. Saha, Maluti Shaha, this is the distributor on the very same day, 14/7. This document.
That is the round seal.
Yes.
That is the signature of the distributor.
Yes. With date, on that means on spot, on the very same day. There is not a single noting so far as these objection related to the payment is concerned. Both the weighing machine, the hand weighing machine as well as the platform based weighing machine, both belongs to the distributor. And if there is a defect in the hand weighing machine, then the responsibility will go to the distributor, not to the wire marketing company. Distributor can't say that the wire marketing company has not followed the rules, because the only case made out in that was been argued is while marketing company has not followed the process as laid down in the discipline guideline, particularly clause 1.4c. And I have shown to my lord that 1.4c is not for compliance of the while marketing company. It is for compliance of the distributor. Now kindly see now this at the top, kindly also see this. I told you, lordships, that the inspection were carried out at 3 different locations. Shop room, go down, route. Now kindly see page 81 on the top, end route.
SQC end route go down.
Right, end route. Now
end route / go down.
End route go down means from go down to the customer. That is end route.
Yes.
Now
why end route / go down it was written?
Because the route is from the go down to the customer.
All are 80 also end route go down?
No, kindly see.
80 also
yes, these are all in respect of because there are 2 delivery vans. Well, your losses will remember there were 2 delivery vans which were inspected. So 80
10 each.
Yes.
10 cylinders each.
Yes. So 80 is in respect of 1, 81 1 is in respect of 1. Now kindly see the other inspection reports which were carried out at other locations, that is the shop room and the go down. Kindly see page 78.
78?
Yes, page 78. Now this is This is in respect of the stock variation, stock. Now, time in go down. Kindly see left hand side.
Time in go down.
Time in go down
9
and
AM.
time out go down. So this is at the go down. So it is not a case that the go down, the inspection, en route inspection and the go down inspections are same thing. Inspection at the go down, the stocks which are there in the go down, and the inspections of the en route cylinders which are loaded for delivery on the vehicle are separate. Both the inspections are independent, separate. This is in respect of the stocks which are there at the go down. Now here kindly see why point in referring to this is whatever objections, whatever suggestions, whatever advice, submissions made by the distributor concerned are also recorded.
So at the time of inspection, distributor can raise objection.
Yes, Mala, kindly see page 78. This entire thing, this has been the any other observation, kindly see the large
So these are the objections of the
certain because certain things were pointed out, certain irregularities. So what was the observation? So far as the irregularities are concerned, those were being explained by the distributor, and she has also signed that on the observation. Kindly see that Maluti Shah 14/7/2024.
Yes.
Kindly see the reason, because these are the reasons which she has pointed out. Kindly see, may I place one by one, my lord? 1 number AC4 and 2 number ERV could not be issued and submitted due to SDMS problem on 13/7/2023.
So this is the explanation of the
distributor. So distributor has a right as well as an opportunity to raise any kind of objection, any kind of observation, objection, whatever may be this thing. Even on the inspection report on spot. And she has done so far as the inspection of the stocks are concerned. Another thing, the next point, due to SDMS problem, partial surrender and TV could not be done on 13/7. Now she has also, in support of the these two explanations, she has referred to the WhatsApp messages which were sent. Reference WhatsApp from AFO on 13/7/2023, 6:33 p.m. SAP is not functional from past 30 minutes. And thereafter, after that observation, she has signed M. Saha 14/7/2023.
Yes.
The next page kindly sees the closing stock report. Even the stock reports which were prepared were also signed by the distributor at the bottom. So there is no scope for any manipulation of the report, and ample opportunity is always given to the distributor concerned to raise any kind of observation or objection in respect of the inspection. And since that opportunity is always given to the distributor at the inspection, during the inspection. Distributor cannot be given a further opportunity to improve our case as a later stage. I may also point out this particular issue in a different matter. However, suppose the entire fault was on the part of the internal corporation. The whatever there's the writ petitioner is taking, the plea that writ petitioner is taking at this point, assuming without admitting, all are correct. Now, I am putting this question to myself, my lord, can the writ petitioner at this stage can at all raise that, can at all take that plea? Because she had an opportunity at the very first instance to take that plea. So if she has not taken that plea, that means she has waived her right to take that plea in future.
Okay.
Now, my lord, kindly, my lord, may I continue on the next step, my lord? I will now, these are the, I have not shown so much of documents. These are my, the primary submissions. Now I will place the documents to support my submissions.
Okay.
Show cause notice, the reply to the show cause notice, all these documents.
Okay, come on next day.
On next Friday. Yes.
Next Friday.
Next Friday.
Argument on behalf of the IOC hard in court. Let the matter be fixed on 31st at 2 p.m. for further argument.
আমাকে জাস্ট উইদাউট অ্যারেঞ্জমেন্ট একটা ইউএস আমাকে এই জিনিসটা এসছে
Item number 2, my lord, I beg to appeal for the appellant, my lord. Mr. Medera is supposed to make his sub.
Yeah.
Item number 2, my lord, I beg to appeal for the appellant. Mr. Medera is supposed to commence his argument, my lord.
Mr. Medera is here.
Yes, my lord, I am sorry. He is seen, my lord.
Arbitration and conciliation. Totally.
Please, Your Lordship. My lord, I appear on behalf of the respondent number 2 in this matter. I am also, my lord, the respondent number 2 before the learned arbitral tribunal.
Yes.
Your lordship knows, my lord, that this is an appeal or an application which has been filed under section 37 of the Arbitration and Conciliation Act by Mr. Lakshmipat Surana.
Yes.
My lord, before I move into the factual aspect of the matter, the merits of the matter, my lord, I seek to, my lord, make certain submissions on a point of law with regard to the scope of section 37 of the Arbitration and Conciliation Act.
Yeah.
So that, my lord, once I explain to your lordship, once your lordship has a holistic view as to what powers your lordship has or what your lordship is required to look at in a section 37 matter, thereafter it'll be easier for us, my lord, to place the merits of the matter. So your lordship will know exactly what has to be looked at and what has to be appreciated by your lordship.
Yes.
This matter, your lordship knows, my lord, has a very checkered history. There was already one round of arbitration earlier. In respect of that earlier round of arbitration, your lordship is hearing separate 34 applications. My application is there, Mr. Surana's application is there, and there's another application by another correspondent. So that's the first round of arbitration. The agreement is the same. In the first round of arbitration, Mr. Surana succeeded on some claims. I succeeded on some claims. Both of us are aggrieved, and therefore both of us have filed section 34. In that earlier round of arbitration, there were 2 awards. One is an interim award, and 2 is a final award.
Yes.
What is before your lordship is the challenge to the final award.
Yes.
So far as the interim award is concerned, that interim award dealt with an award asking me or giving Mr. Surana vacant and khas possession of the subject premises. Then when the final award was passed, the final award, of course, takes into note the interim award, and that culminates or merges with the final award. Now, second arbitration has started because Mr. Surana's contention is that despite the interim order in his favor, despite the final award, according to him, I have not yet handed over possession of the subject premises to him. According to him, I am still there in possession of the subject premises. I am enjoying possession of the subject premises. And while I am enjoying and continuing in possession of the subject premises, I am not paying any rent or occupation charges to him. Therefore, he initiates another arbitration against me. Before initiating the arbitration, he files a Section 9 application before this court, which he's well entitled to. Section 9, your lordship knows, my lord, the act specifies Section 9 can be filed before arbitration,
Yes.
during arbitration, and also after arbitration. Most commonly, it is filed before arbitration. In very rare situations, is it filed during arbitration? Maybe if the arbitrator is not well or the arbitrator is not able to take the arbitration forward, then maybe a party can come and file a Section 9 and say, I'm not able to go before the arbitrator, therefore I've come before the court. And after is also typically before the Section 34 or before the execution is filed, there's a 3-month or a 120-day gap. In that period of time, if some relief is required, typically a party may file a Section 9 application. So Section 9 is mostly limited to pre-arbitration, where a party seeks urgent interim relief.
Yes.
This Section 9 was filed. No Section 11 was filed at that point of time. Section 9 hearing went on for quite a while. No added interim relief granted. No interim relief granted. Hearing was continuing. During the course of those hearings, my lord, I had taken the point that yes, if you want some relief, you want some Section 9, where is your intention to go in for arbitration? I questioned him in open court. Taking a cue from that, he filed a Section 11 application asking for appointment of an arbitrator. That Section 11 application, which he had filed initially, was withdrawn, and he was given liberty to file afresh because of some technical defects. Thereafter, he filed a fresh Section 11. In that fresh Section 11, the learned arbitrator was appointed, who has passed the award, the order, which is under challenge before your lordship. Okay. Retired Justice Pratap Kumar Rai. Today, he's no longer the arbitrator because there's been a substitution because his ended by a flux of time. Yeah. So once he filed the application, or once the arbitrator was appointed, Section 9 was still continuing. He filed a Section 17 application before the learned arbitrator, asking for almost identical reliefs. The relief which he sought in the Section 9 was essentially this, that look, the respondents are enjoying possession, they are not paying me anything, kindly pass an award or kindly pass an order asking them to secure the rental amount, the occupation charges. How does he calculate the occupation charges? He says, you were earlier paying me this much, therefore this is what you have to pay on a month-to-month basis. So he essentially asks for security. Kindly bear in mind, my lord, I will of course address the merits of the matter, but also from a legal perspective, he is at the highest an unsecured creditor. He is not a secured creditor. Secured creditor would be somebody who takes a loan or who's given some money and has some property mortgaged in his favor, or who has some collateral given to him, like a promissory note or some land which has been mortgaged. Some security is there. There are a whole lot of other creditors who may have lent money or who may be owed money, but there is no security for them, that in case there's any default on the part of the debtor, the creditor has no security. So today what he is trying to do through that Section 9 and subsequently through the Section 17s, he is trying to secure his claim in the final arbitration. In the arbitration also which he has commenced, ultimately his claim is a monetary claim. He is not really seeking eviction, he is interested in a monetary award. So in pursuance of that claim for monetary compensation, he files a Section 9 claiming security, and the sum keeps going up because as time passes, he keeps on adding various months which have thereafter passed. So Section 9 pending, arbitration commenced, Section 17 filed. There I take the point that, look, you cannot pursue Section 9 and Section 17 simultaneously seeking the same relief. This amounts to forum shopping. So the first Section 17 is dismissed. Then he withdraws the Section 9, which was filed before this court. He does not get any relief there. Once he withdraws it, he files a fresh Section 17 application before the arbitrator, claiming again the same relief, but now the amount has gone up a little bit more because there has been some passage of time. Earlier, if he had claimed 49 crore, now he's claiming 52 or 56 crore, to which he wants security. So far as this Section 17, the second one which is concerned, this is the subject matter of this Section 37 appeal. The learned arbitrator heard the Section 17 in detail. Affidavits were invited. Opposition filed by both the respondent number 1, respondent number 2, reply rejoinder filed, and thereafter the matter was extensively heard by the learned arbitrator. Learned arbitrator essentially held that, look, Mr. Surana, you're not entitled to any interim relief at this juncture because there are triable issues, because yours is not a clear-cut case. There's a big question which has been raised as to whether the respondents are in possession or not. So therefore, at this juncture, I do not find it fit or proper to grant you any interim relief. Also, you're an unsecured creditor at the highest. You're not entitled to secure yourself. Principle, he had sought a attachment also in terms of Order 38, Rule 5. The tests and the standards for satisfying Order 38, Rule 5 are extremely high. He had not satisfied those standards. So aggrieved by that order passed by the learned arbitrator on November 6th, 2022, he has filed this Section 37. Well, at Section 9 and Section 17 are very similar in nature. Section 9 says you go before the court. Section 17 says once the arbitral tribunal is constituted, you go before the arbitral tribunal seeking whatever interim relief you want. In fact, Section 9, subsection 3 also says that if once an order is passed in your favor, then within 90 days, arbitration has to commence. And thereafter, whatever remedy you have to pursue it before the arbitral tribunal. Section 9, my lord, contemplates urgent interim relief. Something like in a suit. Yes. One files a plaint, one files the suit. Along with that, one may file an application under Order 39, Rule 1 and 2, seeking injunction. One may file an application under Order 38, Rule 5, seeking attachment. Because there is an urgency. Some interim protection is required till the suit is finally adjudicated. Yes. Similarly, arbitration also, till the arbitration is finally decided, whether the award is passed in favor of the claimant or in favor of the respondent, if some protection is required, then you file a Section 17 application, which would have been a Section 9 prior to the arbitration starting. So therefore, my lord, the lordship will also have to look at, my lord, whether any ground of urgency is made out. That is another aspect. whether there was any delay in respect of Mr. Surana filing the Section 9 or Section 17 is concerned. Because your Lordship will note, and I'll show those, I'm just giving your Lordship a brief overview. He is claiming, my lord, occupation charges from me from 2013 onwards. It's been almost 12 years. The very first time when he filed the Section 9 application was filed, my lord, sometime in 2016 or 17. Then, my lord, Section 9 was filed, claims are from 2013. Section 9 filed in May 2017. Section 11, wanting arbitration, filed in November 2017, dismissed in 2019, and then ultimately he files the second Section 11 in 2020. Well, at no point of time has he shown that there is any urgency, keeping in mind that his claims are supposedly from 2013 onwards. That's another point which I will argue. My strongest point, and let me place that first, which I will argue before your Lordship, is that I am not in possession of the premises.
Yes.
That is my strongest point. The sine qua non, or the first thing which Mr. Surana has to show if he is entitled to any order from the arbitral tribunal or from your Lordship in this appeal, if he is claiming occupational charges or security in respect of occupational charges, it is necessary for him that he has to show that I am in possession of the premises. The onus is on him. The burden of proof is on him. He has to show that I am in possession. I categorically state that I am not in possession.
Yes.
And in support of my statement that I am not in possession, I will rely on the final award passed in 2016 in the first arbitration. In that award, your Lordship has perhaps seen some of the paragraphs during the course of the Section 34. The learned arbitrator, Mr. Shama Prasad Sarkar, he was the arbitrator in the first arbitration, he's no more. He has categorically held that possession was handed over to Mr. Surana. Kindly bear in mind that the first arbitration, there was a full-fledged trial. Evidence was led by both sides. Witnesses were produced. Plethora of documents were looked at, which is before your Lordship in some 12 or 15 volumes. And after considering all that, after the full-fledged trial, the learned arbitrator came to the categorical conclusion that yes, the respondents had handed over possession in April 2012. That, my lord, is a finding of fact. Today, that finding of fact will necessarily operate as res judicata. Today, until and unless that finding of fact is reversed,
Yes.
there can be no argument whatsoever made by Mr. Surana that the respondents are still in possession of the premises. Today, in this Section 37 appeal, your Lordship is not sitting in appeal over the final award. That your Lordship is hearing separately in the Section 34 matter. So whatever finding, whatever conclusion is there in that final award is necessarily binding on your Lordship in this Section 37 appeal. That was my contention also before the learned arbitrator in the Section 17 matter, and that has been held in my favor. So today, until and unless he crosses the hurdle that, look, are the respondents in possession? I have a categorical finding that I have handed over possession. It is not his case that after handing over possession, I have again come back in possession. That is not his case. He could have argued, yes, Mr. Future Market Network Limited, you handed over possession in April 2012. Thereafter, again, possession was handed back to you, and therefore you're enjoying possession today. His case is, I have never left or vacated the premises. And that runs completely contrary to the findings in the final award of May 2016. That will be my principal thrust of my arguments.
Okay.
Before I go into these arguments and the documents in detail, my lord, my legal submission, which I said I will make today, is so far as scope of Section 37 is concerned. My humble submission before your Lordship that scope of Section 37 appeal is very limited. Section 17 itself is in the nature of a discretionary power given to the arbitral tribunal. Your Lordship sitting in appeal over a decision of an arbitrator in a Section 17 matter cannot substitute your Lordship's view in place of the arbitrator's view, unless it is shown that what the arbitrator has done is patently illegal or perverse. If there are two plausible views and the arbitrator has taken one particular view, then that view has to be taken.
Yes.
Till the final arbitration. It is not that Mr. Surana's case in the arbitration has been shut forever. The learned arbitrator has merely held that at this juncture, at this interlocutory stage, I feel you're not entitled to any relief, you're not entitled to security, or you're not entitled to occupational charges. This will be a matter of trial. So ultimately in the arbitration, Mr. Surana may succeed or he may not succeed. So the point which I'm trying to make is the doors have not yet been shut on Mr. Surana. Mr. Surana is not left remediless so far as his claim for occupational charges is concerned. At this point of time, he cannot claim occupational charges or security from me in a particular interlocutory proceeding. That will be my submission. So far as Section 37 is concerned, my lord, and the scope of Section 37 is concerned, there are not too many judgments, especially of the Calcutta High Court, which is why, my lord, I invite your lordship, my lord, to pass a judgment which will lay down the law of our court so far as Section 37 is concerned. There are quite a few Delhi High Court judgments on this point, so I'll rely on them, and I'll also rely on a Kerala High Court judgment. Well, the first judgment which I seek to place reliance on is the judgment of the Delhi High Court, reported in 2020, SCC Online, Delhi 2099. Well, I'll just indicate the paragraph numbers first, and then I'll take your lordship through the paragraph.
Yes.
Paragraphs 55 to 60.
Yes.
64 to 74. And 114 to 116. Citation. My lord, will kindly come to para 55, which is at internal page 20. Page numbers are written at the top left corner, my lord.
Scope of reference under Section 37.
Yes, yes, absolutely, madam. I'm grateful. Para 55, my lord. Before proceeding to examine the submissions of learned senior counsel as advanced before me, it would be appropriate to address, in the first instance, the scope and ambit of Section 37 of the 1996 Act, especially apropos the jurisdiction of this court to interfere with interlocutory orders passed by the learned arbitrator under Section 17. Our case, my lord. Because Section 37 will also come into the picture in a Section 34 also. In case the Section 34 is dismissed or whatever order is passed by your lordship in Section 34 matter, that can also go up in appeal in Section 37.
Appeal is only one provision.
Yes. So appeal can be from a Section 34 proceeding, or it can be from certain orders passed by the arbitral tribunal like a Section 17. So this particular case dealt with appeal so far as Section 17 is concerned, which is our case. Para 56, my lord. Section 37, on its plain reading, provides for an appeal against certain orders. The provision does not define the scope and extent of the said jurisdiction of the High Court in the matter of entertaining and disposing of the appeal. Nor is there any other provision in the 1996 Act which enlightens on this aspect. For ready reference, Section 36 may be reproduced thus. Well, I'll place the section also now. Section 37, appealable orders. Notwithstanding anything contained in any other law for the time being in force, an appeal shall lie from the following orders and from no others to the court authorized by law to hear appeals from original decrees of the court passing the order, namely A, refusing to refer the parties to arbitration under Section 8, B, granting or refusing to grant any measure under Section 9, C, setting aside or refusing to set aside an arbitral award under Section 34. Subsection 2, which is what we are concerned with, my lord. Appeal shall also lie to a court from an order of the arbitral tribunal, A, accepting the plea referred to in subsection 2 or subsection 3 of Section 16, or B, this is what we are concerned with, my lord, granting or refusing to grant an interim measure under Section 17. Subsection 3, no second appeal shall lie from an order passed in appeal under this section, but nothing in this section shall affect or take away any right to appeal to the Supreme Court. So SLP can always be filed.
Yes.
Para 57. Oftentimes, the question arises as to whether the jurisdiction of the High Court under Section 37 is subject to the same circumscriptions as formed by its jurisdiction under Section 34. Mr. Nair had submitted before me that it would be folly to restrict the jurisdiction of the High Court under Section 37 by the principles which apply to Section 34. He had sought to emphasize that the jurisdiction vested in the court by Section 37 was appellate, unlike Section 34. Appellate jurisdiction by its very nature, Mr. Nair had sought to submit, is wider than the jurisdiction which applies to consideration of objections against an arbitral award. Appellate jurisdiction encompasses, within its fold, the power to review findings of fact, and in fact, the appellate court is jurisprudentially an extension of the original court, the appeal being a continuation of the original proceedings. As such, Mr. Nair had sought to submit the High Court exercising appellate jurisdiction under Section 37 should not feel restricted by the constraints which govern its jurisdiction under Section 34. Very well. Para 58. Empirically viewed, Mr. Nair's submissions appear attractive. There is undoubtedly, qualitatively, a distinction between appellate jurisdiction and judicial review jurisdiction. Appellate jurisdiction, equally, is classically regarded as an extension of original jurisdiction, the appellate proceedings being an extension of the original proceedings. The appellate court is therefore ordinarily empowered to reappreciate finding of facts entered by the original court. That the jurisdiction of the appellate court is much wider than the jurisdiction of a court exercising judicial review of any other kind is also classically well settled. Para 59. Legal principles are, however, in every instance, required to be applied to the factual scenario in which their application is invited. While, therefore, appreciating the jurisdiction of the High Court under Section 37 of the 1996 Act, we are required to be aware of the fact that the order, interference with which is being invited, was passed by an arbitrator or arbitral tribunal. The sanctity attached to arbitral awards, especially in the context of the 1996 Act, which is based on the UNCITRAL model, has therefore necessarily to be borne in mind while exercising jurisdiction over the decision of the arbitrator, whether in the form of a final award or an interim award under Section 17. Para 60. In the opinion of this court, another important and peculiar feature of the 1996 Act, which must necessarily inform the approach of the High Court, is that the 1996 Act provides for an appeal against interlocutory orders, whereas the final award is not amenable to any appeal, but only to objections under Section 34. If the submission of Mr. Nair, as advanced, were to be accepted, it would imply that the jurisdiction of the court over the interlocutory decision of the arbitrator would be much wider than the jurisdiction against the final award. Though jurisprudentially, perhaps such a position may not be objectionable, it does appear incongruous and opposed to the well-settled principle that the scope of interference with interim orders is ordinarily much more restricted than the scope of interference with the final judgment.
Yes.
Now, my lord, will kindly come to para 64. The next to next page, page 24. There can be no gainsaying the proposition, therefore, that while exercising any kind of jurisdiction over arbitral orders or arbitral awards, whether interim or final, or with the arbitral process itself, the court is required to maintain an extremely circumspect approach. It is always required to be borne in mind that arbitration is intended to be an avenue for alternative dispute resolution and not a means to multiply or foster further disputes. Where, therefore, the arbitrator resolves the dispute, the resolution is entitled to due respect and save and except for the reasons explicitly set out in the body of the 1996 Act, is ordinarily immune from judicial interference. Para 65, my lord. Interestingly, while examining in Snehodeep Structures Private Limited versus Maharashtra Small Scale Industrial Development Corporation Limited, the scope of the expression appeal as employed in Section 7 of the Interest on Delayed Payments to Small Scale and Ancillary Undertakings Act 1993, the Supreme Court held that if the meaning of appeal is ambiguous, the interpretation that advances the object and purposes of the legislation shall be accepted. Purposive interpretation, as has been noticed in Sailesh Daryawan versus Balkrishna Lalla and Richa Mishra versus State of Chhattisgarh, has over time replaced the principle of plain reading as the golden rule for interpreting statutory instruments. Para 66. In my opinion, this principle has to guide strongly the approach of this court while dealing with a challenge such as the present, which is directed against an order which, at an interlocutory stage, merely directed furnishing of security by one of the parties to the dispute. So here, security was granted. In our case, security was not granted, but principles will remain the same. The power of the learned sole arbitrator to direct furnishing of security is not under question. Indeed, in view of subclause B of Section 17(1), subsection 2 of the 1996 Act, it cannot. The arbitrator is under the said subclause entirely within his jurisdiction in securing the amount in dispute in the arbitration. Whether in exercising such jurisdiction, the arbitrator has acted in accordance with law or not, can of course always be questioned. While examining such a challenge, however, the court has to be mindful of its limitations in interfering with the decision of the arbitrator, especially a decision taken at the discretionary level and at an interlocutory stage. These words are crucial, my lord. 67. One may also refer in this context to Section 5 of the 1996 Act, which reads as under. Section 5, my lord. Extent of judicial intervention. Notwithstanding anything contained in any other law for the time being in force, in matters covered by this part, no judicial authority shall intervene except where so provided in this part. So judicial intervention is limited. So purposive interpretation. That's why the judge looked at Section 5. Para 68, my lord. It is, no doubt, possible to argue that the intent of Section 5 is to restrict judicial intervention with arbitral proceedings and orders passed therein to the avenues for such interference as provided by Part 1 of the 1996 Act, and not to restrict the scope of the sections and the provisions contained in Part 1. Perhaps. Section 5 remains, however, a clear pointer to the legislative intent permeating the 1996 Act that judicial interference with arbitral proceedings is to be kept at a minimum. Significantly, in Venture Global Engineering versus Satyam Computer Service Limited, it was opined that the scheme of the 1996 Act was such that the general provisions of Part 1, including Section 5, will apply to all chapters or parts of the Act. In State of Kerala versus Somdat Builders Limited, a division bench of the Kerala High Court held that the jurisdiction of the court under Section 37 of the 1996 Act was also required to be interpreted in the light of the legislative policy contained in Section 5. I entirely agree. Para 69, my lord. The principle of least intervention by courts was held in Enercon India Limited versus Enercon GmbH, Supreme Court decision, my lord, to be well recognized in arbitration jurisprudence in almost all jurisdictions. In a similar vein, earlier in point of time, the Supreme Court held in P. Anand Gajapati Raju versus PVG Raju that Section 5 brings out clearly the object of the new Act, namely that of encouraging resolution of disputes expeditiously and less expensively, and when there is an arbitration agreement, the court's intervention should be minimal. Likewise, albeit in the context of Section 34, it was held in McDermott International Incorporated versus Burn Standard Company Limited thus, and it's quoted, my lord, the 1996 Act makes provision for the supervisory role of courts for the review of the arbitral award only to ensure fairness. Intervention of the court is envisaged in few circumstances only, like in case of fraud or bias by the arbitrators, violation of natural justice, etc. The court cannot correct errors of the arbitrators. It can only quash the award, leaving the parties free to begin the arbitration again if it is desired. So the scheme of the provision aims at keeping the supervisory role of the court at minimum level and this can be justified as the parties to the agreement make a conscious decision to exclude the court's jurisdiction by opting for arbitration as they prefer and finality offered by it. Paragraph 70, my lord. Though the above exposition of the law is in the context of section 34, the principles enunciated thereby embody the general philosophy underlying the 1996 Act. The italicized words towards the conclusion of the paragraph, especially, would apply with equal force to challenges to interlocutory orders of arbitral tribunals under section 37, as they would to challenges to the final award under section 34. Para 71. Section 37 is, in a sense, a somewhat peculiar provision as against the decision of the arbitrator. It provides for a first appeal as well as a second appeal to the High Court. Subsection 1 provides for an appeal to the High Court from the decision of the Section 34 Court, before which the final award has, in the first instance, been tested. Subsection 2, on the other hand, provides for a first appeal against interlocutory orders of the arbitral tribunal under Section 16 or Section 17. There is necessarily a qualitative difference between these two challenges, though both would lie to the High Court. The challenge under Section 37, subsection 1, which is directed against a final award of the arbitrator or arbitral tribunal, is akin to a second appeal, as was observed by this court in MTNL versus Fujitsu India Private Limited. The challenge under Section 37, subsection 2, on the other hand, is directed against the decision of the arbitral tribunal and has therefore, in my opinion, necessarily to conform to the discipline enforced by Section 5. It would therefore be improper for a court to treat an appeal under Section 37(2) of the 1996 Act as akin to an appeal under the CPC or as understood in ordinary or extraordinary civil law. An appeal against an order by an arbitrator or by an arbitral tribunal is an appeal sui generis, and interference by the court in such appeals has to be necessarily cautious and circumspect. Para 72, this position would stand especially underscored where the order under challenge is discretionary in nature. Orders of arbitrators or arbitral tribunals which are amenable to appeal under Section 37, subsection 2, have statutorily to have been issued either under Section 16(2) or 3 or under Section 17. Section 16, subsection 2 and 16, subsection 3 essentially deal with rulings on the jurisdiction and authority of the arbitral tribunal to arbitrate. Any order passed under either or both of these provisions has therefore necessarily to partake of a purely legal character. Such an order would not ordinarily be discretionary in nature. Section 17, subsection 1, an application of Order 39 CPC thereto. There seems to be something missing, my lord. Anyway, my lord, kindly take the next page, para 73. As against this, orders which are appealable under Section 37(2)(b) are orders granting or refusing to grant interim measures under Section 17. Section 17, subsection 1, for its part, reads thus. May I please Section 17 at this moment, my lord? Section 17, interim measures ordered by arbitral tribunal. 1. A party may, during the arbitral proceedings, apply to the arbitral tribunal, subsection 1, for the appointment of a guardian for minor or person of unsound mind for the purpose of arbitral proceedings. We're not concerned with this. We are concerned with subsection 2, for an interim measure of protection in respect of any of the following matters, namely, A, perhaps does not concern us, the preservation, interim custody or sale of any goods which are the subject matter of the arbitration agreement. So this does not concern us. What concerns us, my lord, is B, securing the amount in dispute in the arbitration. C, again, does not concern us, but nonetheless, the detention, preservation, or inspection of any property or thing which is the subject matter of the dispute in arbitration, or as to which any question may arise therein, and authorizing for any of the aforesaid purposes any person to enter upon any land or building in the possession of any party, authorizing any samples to be taken or any observation to be made or experiment to be tried, which may be necessary or expedient for the purpose of obtaining full information or evidence. D, interim injunction or the appointment of a receiver. E, such other interim measure of protection as may appear to the arbitral tribunal to be just and convenient. And the arbitral tribunal shall have the same power for making orders as the court has for the purpose of and in relation to any proceedings before it. Para 74. The concluding caveat in section 17 subsection 1 makes it abundantly clear that the power of an arbitrator to grant interim measures under section 17 subsection 1 is analogous and equivalent to the power of a court to pass such orders. Section 9 of the 1996 Act grants co-equal jurisdiction worded in identical terms on the court to pass interim orders, concluding with a parallel caveat to the effect that the court shall have the same power for making orders as it has for the purposes of and in relation to any proceedings before it. Now, my lord, the last 2 or 3 paragraphs which I seek to read on, para 114. 114 to 116. The third last, one of the last few pages, my lord. Page 47.
Conclusion.
Conclusion, my lord. Grateful. This court, while exercising appellate jurisdiction under section 37 subsection 2 of the 1996 Act over the interim order of the learned sole arbitrator, is not expected or even required to delve deep into the facts of the case. Nor is it expected to substitute its own discretion for the discretion of the learned sole arbitrator. If the exercise of discretion by the learned sole arbitrator suffers from patent illegality or is otherwise unconscionable in law or in facts, interference may be justified, never otherwise. Para 115, judicial intervention with arbitral proceedings has necessarily to be reduced to a bare minimum under the 1996 Act. Applying the salutary principle, I am of the opinion that were this court to set aside or even modify the direction of the learned sole arbitrator to DGG to furnish security for the amount in dispute in the arbitration, which clearly is within the province of the jurisdiction of the learned sole arbitrator conferred by section 17, subsection 1, subsection 2, subclause B, it would do violence to the entire ethos of the 1996 Act and would militate against the avowed objective of the legislation itself. Para 116, my lord. In my view, any interlocutory order by the arbitrator under section 17 to furnish security, if preceded by adequate examination and appreciation of the facts and the rival stands of the parties, should remain impervious to judicial interference. The court is required to adopt a holistic and comprehensive view in such cases. Any attempt by the court to vivisect microscopically the order of the arbitrator to find flaws would be entirely inappropriate. So long as the decision is informed by adequate application of mind, it should be allowed to prevail, especially as it is in the nature of an interlocutory direction and is always subject to the final award to be passed in the arbitral proceedings. So, my lord, this is a comprehensive judgment, my lord,
Yes.
laying out the scope and the powers in under section 30. The next few judgments on this point, my lord, I won't place in much detail, just one paragraph from each judgment, my lord. The next judgment is reported in 2023, SCC Online Delhi 2069. I'm going in chronological order. The first judgment which I placed was of September 17, 2020, Delhi High Court. This one, my lord, is of April 11, 2023.
Mr. Medra, can you repeat the citation, please?
Yes, of course. 2023 SCC Online, Delhi 2069. I have also handed over a copy of the judgment, my lord, to your to Mr. Paul, to your junior.
Okay.
Para 38, my lord. That is, my lord, at internal page 35. Towards the bottom of the page. Para 38.
Yes.
Para 38. It would thus appear to be well settled that the powers under section 37 subsection 2 clause B is to be exercised and wielded with due circumspection and restraint. An appellate court would clearly be transgressing its jurisdiction if it were to interfere with a discretionary order made by the arbitral tribunal merely on the ground of another possible view being tenable or upon a wholesome review of the facts. The appellate court substituting its own independent opinion in place of the one expressed by the arbitral tribunal. The order of the arbitral tribunal would thus be liable to be tested on the limited grounds of perversity, arbitrariness, and a manifest illegality only. So, my lord, mostly echoing what the earlier judgment has said. The third judgment on this point, my lord, is of a later judgment. Again, the Delhi High Court, my lord, reported in 2024 SCC Online, Delhi 1146. LA Lagos. Kindly give me a moment. Well, there only one paragraph from this judgment, just to show, my lord, that the view is consistent. Para 15. That internal page 5.
Yes.
Para 15, my lord, just one paragraph. Before dealing with these contentions, it may be noted that the scope of interference with the Section 17 order in exercise of jurisdiction under Section 37 has been held by this court to be fairly narrow. In some judgments, this court has even equated it to the nature of jurisdiction under Section 34 of the Act. In any event, the principles of restricted interference with interlocutory orders laid down by the Supreme Court, inter alia, in Wonder Limited versus Antox India Private Limited, have consistently been held to be applicable while exercising Section 37 jurisdiction as well. The following extract from this court's recent decision in Tehel Consulting Engineering India Private Limited versus Promax Power Limited summarizes the legal position thus. That, my lord, is the paragraph which I've already placed of the earlier judgment, para 38. So I'm not troubling your lordship again with that. My lord, next, my lord, is another recent judgment of 1st October 2024. I'm not too sure if it is reported or not, but I'll give my learned friend a copy. Again, of the Delhi High Court. And these are all, my lord, interestingly, all different judges of the Delhi High Court. Single bench, division bench, etc. My lord, here, my lord, paragraphs 31 to 36. For Mr. Paul's benefit, the cause title is Shamlaji Expressway Private Limited versus National Highways Authority of India. Just a few short paragraphs, my lord, 31 to 36. The last 3 pages. Lordship has para 31. It is also notable that the legal position is well settled to the effect that while entertaining the appeal from an order passed by the arbitral tribunal under Section 17 of the Arbitration and Conciliation Act, this court would not supplant the conclusions drawn by the arbitral tribunal, which are based on an intricate factual examination of the matter. Para 32. In World Window Infrastructure Private Limited versus Central Warehousing Corporation, reported in so-and-so, it was observed by a coordinate bench of this court as under. Para 29, my lord, of the quoted judgment. The scope of interference in appeal against orders passed by arbitrators on applications under Section 17 of the 1996 Act is limited. This court has already opined in Dinesh Gupta versus Anand Gupta, which I have placed, Augment Gold Private Limited versus 197 Communication Limited, and Sanjay Arora versus Rajan Chadda, that the restraints which apply on the court while examining a challenge to a final award under Section 34 equally apply to a challenge to an interlocutory order under section 37, subsection 2, clause B. In either case, the court has to be alive to the fact that by its very nature, the 1996 Act frowns upon interference by courts with the arbitral process or decisions taken by the arbitrator. This restraint, if anything, operates more strictly at an interlocutory stage than at the final stage, as interference with interlocutory orders could interfere with the arbitral process while it is ongoing, which may frustrate or impede the arbitral proceedings. Next para, 30. Views expressed by arbitrators while deciding applications under section 37 are interlocutory views. They are not final expressions of opinion on the merits of the case between the parties. They're always subject to modification or review at the stage of final award. They do not, therefore, in most cases, irreparably prejudice either party to the arbitration. Section 17, like Section 9, is intended to be a protective measure to preserve the sanctity of the arbitral process. The preeminent consideration which should weigh with the arbitrator while examining a Section 17 application is the necessity to preserve the arbitral process and ensure that the parties before it are placed on an equitable scale. The interlocutory nature of the order passed under Section 17, therefore, must necessarily inform the court seized with an appeal against such a decision under Section 37. Additionally, the considerations which apply to Section 34 would also apply to Section 37, subsection 2, clause B, qua the impugned order dated 17 June 2020 in first Section 17 application. Para 33, again, in Dinesh Gupta and others versus Anand Gupta and others, 2020 so-and-so, it was observed as under. This judgment I've already placed, my lord. Para 59 also I've placed. Kindly come to para 34. The view taken by the arbitral tribunal in the present case is based on a detailed factual examination and considers all relevant aspects of the matter, including the adverse financial impact on the appellant of the vacation of stay on the suspension. It was found that the same does not outweigh the multiple factors which are set out in the impugned order. The view taken by the arbitral tribunal cannot be said to be perverse or irrational. Moreover, the same is inherently subject to the final outcome of arbitration and without prejudice to the right of the appellant to claim appropriate final reliefs, including damages. It is also notable that in terms of the provisions of the CA, the suspension of the concession under Article 30 thereof can only be for a period not exceeding 180 days from the date of issue of such notice, extendable only by a further period not exceeding 90 days. Therefore, other contractual consequences as envisaged in the CA, that is concession agreement, have to ensue. Necessarily, all these aspects will be gone into by the arbitral tribunal in the due course of arbitral proceedings. Para 36, turning over, last minute. In the circumstances, this court finds no merit in the present appeal. The same is accordingly dismissed. Now that I've placed 4 Delhi High Court judgments, all by different judges, all 4 separate single judges, my lord, but all echoing and saying the same thing. Lastly, my lord, to show, my lord, that even the Kerala High Court is of the same view, kindly, my lord, permit me to place a judgment of the Kerala High Court, a division bench, reported in 2022, SCC Online, Kerala 344. I will just trouble your lordship with only one paragraph from this judgment. Paragraph 34. In the second last page, the penultimate page, my lord, towards the bottom. Internal page 16. The court below refused to interfere with the award on this score also. It found that the tribunal had considered all the relevant materials and evidence before it arrived at the conclusion. Therefore, relying on McDermott International Incorporated, this was also relied on by the Delhi High Court in one of the judgments, versus Burn Standard Company Limited, reported in 2016, volume 11, SCC 181. The court held that appreciation of evidence is the realm of the tribunal, and that the court under section 34 cannot reappreciate the evidence as is done in civil appeals, and that it is only when the tribunal bases its conclusion on irrelevant and extraneous matters an interference would be called for. In the instant case, the tribunal has not considered any irrelevant evidence or extraneous matters, and therefore the court below refused to interfere with the matter. The conclusions arrived at by the tribunal, as rightly held by the court below, are conclusions arrived at by the tribunal after appreciating the evidence on record. The court below under section 34 or this court under section 37 cannot reappreciate the evidence and substitute its own views or findings, even assuming that a different view is possible. In these circumstances, we find no infirmity or perversity as contemplated under section 2A of section 34 in the findings of the tribunal, and therefore the court below was right in refusing interference. This judgment perhaps will be, my lord, more useful for the other section 34 applications which your lordship is hearing, because this deals with more with section 34 and section 37 arising out of a section 34. So, my lord, these are the 5 judgments, my lord, which I seek to rely on, my lord, for the purposes of determining what the scope of section 37 is. So, my lord, what flows from these judgments, scope of section 37 is very limited. Lordship has to be circumspect. Your lordship cannot substitute your lordship's view with the arbitrator's view. If the arbitrator has taken a view which is a possible view, that view must be given effect to. Only if it is a case of perversity or patent illegality, then your lordship can, of course, interfere. Moreover, and more importantly, my lord, the objective of the Arbitration Act from a purposive interpretation point of view is to keep interference of courts to a minimum. The arbitral tribunal, especially in this case, has had a detailed hearing. I think we had some 16 or 17 hearings before the arbitral tribunal, so far as the section 17 matter is concerned. So it has considered everything. It's a well-reasoned order. And although the order has gone against the appellant may still succeed in the final award. So it is not like the doors are being shut. In the arbitration, this is only at the interlocutory stage. Evidence is going on right now. Once Mr. Surana leads evidence, maybe he will be able to show that I am in possession. So we have to wait for that moment. As of this moment, I was able to satisfy the tribunal based on the findings of the earlier award that I am not in possession. And that is what I will come to now on the merits of the matter. Mr. Surana's appeal under section 37, what he's filed, the memorandum of appeal and the stay petition, very conveniently, he did not enclose the final award. But I brought that final award on record, my lord, in a compilation of documents which I have filed. My lord will kindly take that compilation. My lord, the award starts at page 1 of this compilation. The award, my lord, is dated May 19, 2016. This, my lord, is the first arbitration final award. There was an interim award also, which I will come to. But first, my lord, let me place my strongest cards on the table first and satisfy your lordship that I am not in possession. And therefore, there is no question of any security or any occupational charges. My lord, I'll seek to rely on, my lord, 9 paragraphs of this award, paragraphs 33 to 41, which start at page 20 onwards. Para 32 onwards, para 32 to 41. Page 20, my lord.
Yes.
And we'll see, my lord, para 32 at the bottom. My lord, may I place these paragraphs? These are the paragraphs, my lord, which will clearly establish that possession was handover, and that is the finding which the learned arbitrator has come to. The claimant argued that the letter dated 31st October 2011, this was issued by me, my lord, cannot be treated as a termination of the agreement since the respondents did not and could not give vacant possession of the licensed premises under clause E22. Hence, the agreement is still subsisting, with the consequence that the respondents continue to remain liable to pay license fees to the claimant even now and until the former are in a position to deliver vacant possession. So Mr. Surana's case was that until and unless you give me vacant possession, it is deemed that the respondents are in possession and you have to keep paying me rent. Kindly see what the arbitrator holds. Under clause E22, the respondents as sublicensees were obliged on expiry of term or earlier termination of the agreement to yield up and deliver unto the licensee vacant and peaceful possession of the said premises in the same condition in which the same was let out to the sublicensees, subject to normal wear and tear. Para 33, my lord. It is significant to note that the said clause E22 also entitled the respondents on determination of the agreement to remove and take away all its goods, articles, fixtures, etc. Likewise, they were also entitled to refund of the security deposit paid by them in terms of clause E5 of the agreement. By their letter dated 12th April 2012, my letter, my lord, Annexure D at page 54 of the counter statement, the respondents expressed their readiness and willingness to hand over the licensed premises to the claimant in accordance with the termination letter dated 31st October 2011, requesting the claimant to be present on 14th April 2012 at Puja Mall. None apparently turned up. Now, my lord, mark the next few words, my lord. In such circumstances, the respondents justifiably contended that possession was in effect handed over on 14th April 2012. The claimant, by his letter dated 19 December 2011, written in reply to the termination letter, accepted the termination, but raised various claims and exercised lien on basis of said alleged outstanding dues estimated at rupees 22 crore 62 lakh 61,023 over all goods, materials, equipments stored in the scheduled premises, adding that security deposit would be refunded only upon payment of such outstanding due with interest at the rate of 18% per annum. Para 34. On this footing, the respondents contended that they were only obliged to pay license fee for the period from 11th August 2008 to 14th April 2012, subject to their claim for set-off on various counts. Para 35, my lord, is important because this deals with Mr. Surana's contention on vacant and possession. True, the respondents have not delivered possession in terms of clause E22, but such a conduct, though may have other legal consequences, such as entitling the claimant to evict the respondents as well as their sublicensees from the scheduled premises and claim compensation or damages, would have no relevance to the question of termination of the agreement. Clause E22 itself provided that obligation to yield up and deliver vacant possession would arise on expiry of the termination or determination of the agreement. It is thus an independent obligation and not meant to be a prescribed mode or manner of determination of the agreement. Determination of agreement, like its making, is a question of law. The agreement is not terminated by breach alone. This only amounts to, in legal phraseology, repudiation of the agreement, and an unaccepted repudiation is a writ written in water. It is only when innocent party accepts such breach, the agreement stands determined. Letter dated 31st October 2011 was really an acceptance of such repudiation of various breaches referred to therein, resulting in termination of the agreement. As a matter of fact, this is important, my lord, I do not accept the claimant's contention that allowing the shop owners and sub-licensees and others to occupy the demised premises, the respondents failed to yield up and deliver the demised premises. So, my lord, Mr. Surana's contention before the arbitrator was shot aside. Learned arbitrator held that just because you have not handed over vacant possession does not mean that the agreement is not terminated, does not mean that you have not handed over possession. Now, para 36, my lord. By a supplemental agreement dated 14th June 2008, Respondents Documents Volume 1, page 428, of the respondent as sublicensee was empowered to further sublicense a portion of the demised premises, which they did. Such sub-sublicensees were thus allowed to occupy portion of the scheduled premises with consent of the claimant. Besides, the said sub-sublicensees, in circumstances explained hereinafter, began to pay rent to the Union Bank, the banker of the claimant. These are findings of the arbitrator, my lord, with express or implied consent or approval of the claimant. Though it is not clear from materials on record whether such payments were made by the sub-sublicensees in discharge of the respondent's liability to the claimant or otherwise, the fact cannot be disputed that such payments were made by sub-licensees to the credit or for the benefit of the claimant. The claimant clearly acquiesced into this arrangement. Kindly mark these words, my lord. Claimant clearly acquiesced into this arrangement. He was happy that the occupiers were paying rent to his bank. He was happy that he did not get vacant possession. Para 37, my lord. In any event, there were a combination of circumstances which made it impossible for the respondents to give vacant possession of the demised premises to the claimant, and not all of those were their own making. Undoubtedly, the respondents could not deliver vacant possession of the scheduled premises for the reason, as would appear from correspondence exchange between the parties, which clearly record that various businesses were being conducted in a part of the scheduled premises, including Big Bazaar, Food Bazaar, owned by Future Value Retail India, by Future Value Retail Limited. One has to see in what circumstances such third parties were inducted or allowed to occupy a part of the scheduled premises. Respondents as sublicensees were entitled, in terms of the agreement dated 14 June 2008, to further sublicense in favor of various business houses. There are common areas shared by all occupiers of the said premises. Kindly note the next few words, my lord, because they talk about the interim award. At any rate, following the interim award passed by me on April 8, 2013, declaring that the claimant was entitled to cast and peaceful possession of the licensed premises, no attempt was made by the claimant to evict such sub-licensees and occupiers of the said premises till date. So the learned arbitrator is very conscious and alive to the fact that an interim award had been passed, and despite the same, the claimant did not take any action, and despite this interim award, the arbitrator has held that possession was in fact handed over on April 2012. Kindly see para 38, my lord. By exercising lien over the goods and articles stored in the said premises, and by refusing the respondents to refund the security deposit in circumstances described above on account of outstanding dues of the respondents, the claimant himself prevented the respondents to deliver back vacant possession of the said premises. So, my lord, the learned arbitrator comes to the finding that yes, you did not hand over vacant possession. Who is responsible for this? The learned arbitrator asked himself, and came to the finding that Mr. Surana himself is responsible for me being unable to give him vacant possession. Today, he cannot now claim that, oh, you're still occupying the premises, you've not given me possession. It's a clear finding of the tribunal. It's a final award. It's not an interim award, my lord. After trial. And he did not mischievously disclose this award in the Section 37 appeal. I had to bring it on record. Kindly take para 39, my lord. Other significant aspect of the matters on the issue of possession arose from the fact that disputes between the parties were overtaken, as it were, by other events, adding altogether a different dimension to the issue. Since various established business houses in the said premises, as referred to above, inducted by the respondents in terms of their supplemental agreement with the claimant, were reluctant to abandon their business and vacate the premises, this resulted in great commotion in the locality, which spiraled beyond the confines of the disputes between the parties. This was subject matter of various meetings involving political leaders, bankers of the claimant, labor commissioner, subdivisional officer Kharagpur, shop owners, and representatives of the staff. Involvement of all these parties were well documented and is particularly clear from various documents in the surrejoinder of the respondents. The shop owners, following such meetings, at the instance of the subdivisional officer Kharagpur, consolidated their possession by forming a registered society. So possession is, my lord, of the shopkeepers, not the respondents, my lord, because I have handed over possession. By forming a registered society, Puja Mall Shop Owners Welfare Society, to protect their interest. As a matter of fact, the said society, by its letter dated 2nd April 2013, page 49 of Anil Cherian's affidavit, he was my witness, paid to the Union Bank, the banker of the claimant, Strand Road, branch, Calcutta, a sum of rupees 35,04,939 to its escrow in final settlement of Big Bazaar premises account for the period of 1st April 2012 to 31st January 2013. Its principal, that is future value, Big Bazaar, etc., in turn, started paying various charges to the said society. A sample invoice of such payment was shown to me by Mr. Jishnu Shah, learned counsel for the respondents, which is at page so-and-so. This was in response to bank's letter dated 29 February 2012, addressed to one of such sub-licensees, by which the bank asked it to pay its rents directly towards liquidation of claimant's liability to the said bank. So that Mr. Surana today is seeking unjust enrichment. Payments are being made to the bank. There's also a receiver. And yet again, he's asking for further occupational charges. It is believed letters in similar terms were addressed to other sub-licensees of the respondents as well. All these referred to wider arrangements to overcome the impasse created by peculiar situation when various business houses inducted by the respondents were reluctant to give vacant possession, jeopardizing their business and possession. There can be very little doubt in my mind that the claimant reconciled himself with this new development, or at least was content to abide by the situation, and in turn, my lord will kindly mark the next few words, absolve the respondents from handing over vacant possession of the scheduled premises in terms of clause E22 of the agreement. Even the court has taken note of the fact that the other parties were in possession of the said premises. A receiver was appointed in a proceeding initiated by Union Bank, the claimant's banker, in terms of an order dated 6th August 2013, passed by the Debt Recovery Tribunal to collect rents from the occupiers. This is clear from the respondent's advocate's letter dated 16th August 2013, which has been disclosed by the respondents in this proceeding. No doubt, this was meant for the benefit of the claimant. Para 40, my lord. In my view, obligation of the respondents to give vacant possession of the scheduled premises in terms of clause E22 of the agreement became unavailable, as at no stage the claimant objected to the course adopted or recorded his reservation to the same. Now he is coming and objecting. He's missed the bus. Para 41, my lord, the last para which I seek to rely on. Finally, the bill dated 14th June 2013, raised by the claimant and addressed to Messrs. Exclusive, one of those occupiers in the said premises, disclosed by the respondents on 16th August 2013, it was recorded that the agreement between the parties was terminated on 31st October 2011 and that an award for eviction had been passed against them. Hence, it was pointed out that the occupation by Messrs. Exclusive was unauthorized and it was suggested that they were liable to be evicted. From the tenor of the said letter, I detect a clear overture to the addressee to enter into a fresh arrangement with the claimant. As is evident from the content of the said letter or bill dated 14 June 2013, that the claimant clearly admitted that the agreement dated 30th January 2007 was validly terminated, making it quite clear that the determination of the said agreement was not dependent upon or in any way related to the issue of possession. So, well, these are the relevant paragraphs of the final award, from which it will be abundantly clear that yes, vacant possession was not handed over, but possession was handed over. It will be clear that I am not in possession of the premises since 14th April 2012. That is a categorical, unequivocal finding of the learned arbitrator. This finding now is binding on all subsequent proceedings. Unless this finding is reversed, we are bound by this method. Well, I'll stop today here, my lord. The next point I'll develop the next argument on the next statement. Okay.
Thirtieth January, second half.
Just kindly give me one moment. I think it should be possible. Kindly give me one moment. Would it be on the 31st, subject to your lordship's convenience?
Yeah. 31st, I have a fixed matter.
That matter which was going on before us
Yes,
today.
yes.
I'll come after that, like today.
Very. 31st.
Grateful, my lord.
Argument on behalf of the respondent, hard in part, that the matter fixed on 31st of January 2025 at 2 p.m. as second matter.
Most grateful, my lord. Allah Kane. Ordering.
আমাদেরটা Friday।